Yes.
Lordship, with the consent of the petitioner, I beg to mention item number 12. Lordship. Yesterday, Lordship, I have given a slip.
Yes.
Can this matter be taken up after 2 weeks, Lordship? I need to file my rejoinder.
You're for the respondent,
Yes, Lordship, Higher Education Department.
Mr. Deepamanyan, and Standing Council Higher Education Department. Appearing for the respondent department submits that he has some personal difficulty to conduct the case today and accordingly placed for adjournment. You say present or opposed to by the other side. Matter stands adjourned.
Date may be fixed, sir.
We listed again on terms.
Highly obliged.
Lordship, with the consent of the other side, I would like to mention item number 10. An additional affidavit need to file, Lordship. 2 weeks' time may be given.
You're for the petitioner.
I'm for the petitioner, Lordship.
Why do you want to file additional? Why do you want to file additional affidavit? Can you hear me?
Yes, Lordship.
Why do you want to file additional affidavit? What is your name?
Lordship, NB Kaistha.
AB Kasta.
NB Kaistha, Lordship.
NB.
Mm.
NB or AB?
NB, Lordship.
Your name is not there in the list? Your name is not there in the cost list?
On the behalf of R. Dubey, Lordship.
NB Kasta Learned Counsel appearing on behalf of Mr. R. Dubai. The engaged counsel for the petitioner submits that petitioner may be allowed to file an additional affidavit. In view of above, have you informed the other side?
Yes, Lordship.
Matter stands adjourned for 2 weeks. Petitioner may file additional affidavit. You should advise in the meantime. List again on so and so.
Mr. Obliged.
May I please, your lordship? My lord, I beg to mention for listing of a urgent motion item today, my lord. Regarding transfer, my lord, I have not been transferred, I have been deployed. There is no provision for deployment of a teacher, my lord. So that is under challenge and deployment more than 100 kilometers from my present school. And I have to draw salary from my present school also. Totally by dehors the rules, my lord. Now, so cause has also been issued and pending departmental proceeding, my lord, as I have not gone there and joined, my lord. Finally, my lord, at 2 p.m., my lord.
Have you filed it or you
Yes, yes, sir. We have filed and number is also there.
When did you file?
Today morning, my lord, today morning.
Okay, in the afternoon.
My lord. Obliged.
Just a minute. You send me the file. Okay. Yes.
21 to 23, Lordship.
Yes, what do you want?
Adjournment for week, Lordship.
You are for which? You are for which side?
Petitioner, Lordship.
You are appearing on behalf of Mr. Khan.
Yes, Lordship, yes.
Why do you want adjournment?
Lordship, we have obtained some instruction, Lord.
So
After a week, Lordship.
there has to be a reason for the adjournment. On the prayer made on behalf of Mr. M. Khan, Learned Counsel for the petitioner. Petitioners. These matters stands adjourned. For a week as paid for. List again on so and so.
May I please, your lordship. I beg to mention for listing a WBC, lordship. For
Motion,
admission.
motion,
Admission, lordship.
admission, you approach the registry, please. Okay.
Lordship, last time, lordship, respondent side take 3 weeks time. Till date, lordship.
I understand, you
Some urgencies there,
you
lordship.
take it up with the registry to list it, okay? Yes.
May I please,
Obliged.
Lordship, with the consent of the other side, I beg to mention item number 25, Lordship. In this case, Lordship, BTC was supposed to file the affidavit, Lordship.
Who?
BTC, Lordship,
Oh.
me. So the affidavit has gone for vetting, Lordship.
Oh.
Kindly fix the matter of 2 weeks, Madam.
Who's for the other side?
I'm, the petitioner is here.
Okay.
That may be.
Counsel for the respondent BTC submits that the affidavit of possession has been sent for vetting, and therefore he prays for 2 weeks' time to file the affidavit. So the said prayer is not opposed to by the other side, and accordingly let the matter be listed again on so and so. Right.
May the Lordship, I beg to mention item number 8, Lords.
Item number
8, Lords.
8.
Matter may be adjourned for 1 week, Lords.
Why?
In this case, Mr. A. Deka will appear and today he is out of station, Lords.
A Deka for petitioner.
Yes, Lord. His name is not shown.
Name is not there. What is your name?
K. Dash, Lords. I am appearing on behalf of K. Devi, Lords.
On behalf of
K. Devi, Lords.
K. Devi. You are appearing on behalf of K. Devi, but you are praying for A Das.
Yes,
A Deka.
K. Dash, Lords.
K. Das.
Yes, Lords.
Okay. On the request made by the learned, on behalf of learned counsel for the petitioner, matter stands adjourned. To be listed again.
Yes.
12:06.
Lordship, I beg to mention for motion listing, Lordship, WBC on next Monday, Lordship.
What matter is that?
Lordship, matter relating to appointment of teacher, Lordship.
Any urgency?
Yes, Lordship. What is the first week of May, any date, Lordship?
Any urgency? No.
Yes, Lordship, relating to appointment of.
Have you filed?
Yes, Lordship. 25.
When did you file?
Lordship, yesterday, Lordship.
Yesterday.
Yes.
It will come in due course. What is the hurry?
Urgencies, Lordship.
It will come in due course.
Yeah.
You file it. No.
All right, Lordship.
Item 1 to 9 are all same, Lordship. Here, Lordship, I have received some instruction regarding item number 3, 5, and 7. Here, Lordship, that on verification that department has found that in some schools, the criteria like permission and recognitions are not there. In some school, Lordship, affiliation is not there. So, there multiple of cases of schools are there. So, verification is going on to get a final Lordship outcome. 10 days time make further be required, Lordship. That is the instruction that I have received
Since the matters are going on in war footing, let the matters be kept at motion stage and a date be fixed. If they give a result to this entire exercise, it's well and good.
to get enrollment, Lordship, they have to be duly get the permission and recognition and affiliation. Those things are not there so far the petition schools are done. So we have received some reports and we are verifying and scrutinizing all the schools. There are 7 schools, Lordships. So I have received the instruction regarding item number 3, 5, and 7, and other also same. So we need a 10 days time to get out the all the things finalized.
Okay.
And come a conclusion, Lordship.
Okay, you take time that. Give him time.
The 8th of May, madam, next Friday.
10 days time.
Because the compartment exams may take place in the month of May. We don't know. The notification is not yet out. So I don't want
Well,
to.
if it did come out, he can mention it. Otherwise, 10 days time may kindly be given. Lordship.
Or 11, 11, Monday.
Okay. Mr. SMT Chisti, Learned Standing Council, Secondary Education, submits that scrutinization and verification of the schools concerned is under process, and therefore he has been asked to obtain. He has been asked to pray for 10 days time to receive complete instructions. In view of above, let the matter be listed on 11th of May 2026. Item 1
to 7, Lordship.
1 to 7. Similar orders.
Similar. Obliged.
What is this letter you've given me?
It is the instruction in one of the case, Lordship, that in this case, recognition is not there, permission is not there.
You take it back.
Yes. I'll submit the.
Orders, item 35.
Where is Mr. Cotton here?
My deep sir is supposed to appear, Lordship. She was allotted with this item.
Who?
And I will call
Who?
deep sir, deep sir, Lordship. But what
Mus-
are see
Mus-
there, Lordship.
Musahari.
Yes, yes.
Okay, passed over, kindly.
36. Yes, 36, Lordship. Everything was done, Lordship. Then the finance has sought some queries. That was the last instruction. Now the director has received the report from the district regarding the name of DO, name of treasury, all the corrections, all the requirements that the finance department that was been sought, and it was sent to the government. And it will ultimately send to the finance, Lordship. Otherwise, everything was done, Lordship. Only finance has to give the approval. The finance sought some queries, those we have received from the district. All the account number, IFSC number, account holder name, all this information we have received from the district, and we have sent it to the commissioner, Lordship. And ultimately it will be sent to the finance for its final approval, Lordship.
That was submitted last time also.
Yes, now report has received. We have sent a report from the, we have received a report from the district, and it was sent by the director to the commissioner on 27th of April. Lordship, it.
So the letter says that details is given by the director to the secretary.
It will be sent to the finance because we have already sent the finance has sought this additional information, Lordship. We have submitted to the finance for its approval.
But there's nothing mentioned here that will be sent to the finance department.
No, it and the secretary will send it, Lordship. It is director has submitted a report to the secretary. Now it will be sent to the because Lordship can turn to third page, Lordship. It is a letter written by the secretary to the director that the official for Assam finance department has verbally pointed out in order to respond the matter. Additional details such as office name, DDO, all these things were required. In the third Lordship letter in the second para.
Third letter is not legible to me.
And it is also not legible, Lordship.
How do you read this third letter?
Second para, it is stated that official of the finance department has verbally pointed out that in order to respond the matter, the additional details such as office name, DDO code, employee bank account, and details used in Assam is necessary, and the file would be formally returned to the school education.
Okay, how much time?
It will be sent to the finance, Lordship. It will be by next week, Lordship.
Next week.
Okay.
None appears for the petitioner when the matter is called. Mr. SMT Chisti, Learned Counsel,
On behalf of B. Kaushik, Lordship.
appearing on behalf of Mr. B.
B.
Kaushik,
Kaushik.
who is the engaged counsel for
Our only sole respondent.
the sole respondent, submits that the Director of Elementary Education has submitted the information required to the Commissioner and Secretary, Government of Assam, Department of School Education. And the Commissioner and Secretary in turn will be forwarding the same to the Finance Department. in response to the clarification sought by them. Copy therefore pays for a week's time to come up with the up-to-date status. Considering the same, list this matter again. 25.
Apply.
37.
37. And appears for the petition of the matters for ends of justice, list the matter again after 2 weeks on a date to be fixed by the registrar.
38.
May I please, Your Lordship? The matter was placed before the, my lord, Lok Adalat, my lord, mediation, my lord. That was not, my lord, done, and accordingly, what I listed before, Your Lordship.
Listed for admission then,
Yes, my lord. Maybe listed for admission, my lord.
parties are represented by the respective councils and they submit that matter was sent for mediation, but the same has failed. In view of above, and has paid for list this matter for in the admission column. On so and so.
My lord, date may be fixed.
15th.
Currently, my lord, pays the order dated 20/04/26, my lord.
Mm.
By this order, my lord, I was asked to file representation before the DEO Dorong, my lord.
Mm.
I went there, my lord, but they refused to accept, my lord. I may be allowed to send it by post, my lord. It's a family pension matter, my lord.
What application was you required to submit?
Well, because, my lord, there was two wives of the deceased, my lord.
Oh.
I'm the second wife, my lord. In the meantime, the first wife died, my lord.
Mm.
Because on that day, my lord, I am the sole, my lord, entitlement of the pension, my lord.
Mm.
Therefore, my lord, order dated 20, my lord, I was asked to file a representation before the DEO. By, my lord, saying all the facts, my lord.
Yes, who's appearing for the DEO? Any
A party,
council?
he is not a party, my lord, yes.
Any council? He is not a party.
My lord, it's a elementary education, my lord.
Why don't you make him a party? Director Elementary Education,
Yes, my lord, he's a party, my lord.
you are there?
For the family pension.
Not for family pension. Are you there for the Director of Elementary Education? That is what I'm asking.
Yes, sir. For the.
Now, court has directed team to submit an application to DEO. Why is he not accepting it? DEO of which district?
Dorong, my lord.
Have to take instruction from the DO Pradesh.
Counsel for the petitioner submits that in terms of the court's order dated 24/2026, the petitioner tried to submit a representation, public application to the district elementary education officer Dorang, but the state authority has refused to accept the same. Some liberty is granted to the petitioner to submit the application by post. The petitioner shall file an affidavit enclosing a copy of the postal receipt after sending the representation by post. Ms. N. Fukan Lanet, Standing Counsel, Elementary Education, shall also obtain instructions in the matter. having regard to the order passed by this court on 20/4/2026. List again on 10/6.
Wait, please, my lord.
Yes,
My lord, I preferred this IA, my lord. The writ petition pertains to, my lord, amalgamation of schools, my lord. You are aggrieved by the said amalgamation order. That was
IA is for what?
IA is for, my lord, restoration of the midday meal, which was cancelled pursuant to the impugned order. And also, my lord, not to give effect to the said impugned order, my lord. 30,
Which impugned order?
my lord would have the main writ petition, my lord, kindly.
No, you come to the IA. Where is the prayer portion?
Yes, my lord.
Page 10.
Yes, my lord.
Why were you absent last time?
My lord, last time, my lord, my friend was supposed to appear. She could not reach, my lord. I apologize for that, my lord. I was in legs and my friend was supposed to appear. She couldn't. My lord, this is the order, my lord, passed by the Director of Elementary Education, Assam, my lord. Whereby, my lord, we were told to amalgamate with the respondent school. We are, my lord, Soraimari Merganda LP school, and we were told to join the Soraimari LP school. Now, my lord, our grievance is that we are on a better footing. However, with regard to the said school, my lord, the respondent school,
What is your prayer in the main writ petition?
my lord, the
Main writ petition.
main writ petition, my lord.
What is your prayer?
That prayer is, my lord, pursuant to this honorable court's order, my lord, we were given a hearing. We were told to appear place our matter, my lord.
Is that the answer?
My
I'm asking you, what is the prayer?
my lord, not yes, my lord, I'm coming to that. My lord, quashing of the order dated, my lord.
4/1/24.
Yes, my lord. My lord, by that order, my lord, our UDIS code was cancelled, my lord. And we were not given a fair opportunity, my lord, by the Joint Secretary, Department of School Education, Assam. That is our case. Violation of natural justice, my lord.
UDIS code of respondent school was activated.
That was activated and ours was cancelled, my lord. Without giving us a fair opportunity, my lord.
Then quashing of impugned order dated 30/1/23.
Yes,
What is
my-
this?
My lord, the main order, that order by which we were told to join the other school, my lord. This is an amalgamation case, my lord. So by that order, my lord, we were told to join.
So that prayer is already there in the writ petition.
It is there, my lord, but.
So why did you file this IA?
My lord, this IA, because, my lord, the midday meal has been stopped by the government on the pretext that because we have not joined the other school, that is why our midday meal of the children has been stopped. Now, my lord, what has happened is that children, my lord, they are poor children. They require that midday meal, my lord. It is a kind of an incentive for them also to attend the school.
Midday meal is, so far as midday meal is concerned,
Yes.
okay, IA is there. But again, you have repeated the prayer of 31,
My lord,
2023.
because, my lord, that has to be stopped. That has to be given effect to, because we were not afforded an opportunity, my lord, fair
Okay,
opportunity. To
what is the response from the other side?
My lord, nothing has been filed yet. Not
Mr.
even.
Chaudhary, you are there for this
Yes, what I SSA.
SSA.
Yes.
Midday meal comes from SSA.
Midday meal, Lordship nodal officer is the deputy commissioner.
DC.
State commissioner.
Okay, who's appearing for the deputy commissioner? Mhm. When was this IA filed?
IA, my lord.
Last year.
Yes, my lord. Last year only filed. Till date, nothing has been done. In fact, in the main writ petition also, no reply has been given. 24 matter, my lord. A humble prayer is that only the restoration of the midday meal may be given till disposal of the main writ petition, my lord.
Today, the matters listed for orders. Kindly tell us whether notice has been effected or not to respondent numbers 8 and 9.
My lord. My lord, may kindly have the
Flag order. What is this flag order?
Steps we had taken, my lord.
Flag order. No. I'm talking about this flag order. In another writ petition. 6906 of 23. This is one flag. But this is not a flag order. Or, okay, so this is the one. Okay, just a minute. This is the one. Hmm. So notice is not yet affected.
My lord, we had taken steps, but. My lord, with due respect, my lord, the midday meal, my lord, the SSA, my lord, which my respected senior appears for, my lord, that can be given effect to, my lord. My lord, children, my lord, at the end of the day, my lord.
Who are respondent numbers 8 and 9, by the way?
8 and 9 is the other school, my lord. My lord, on the strength, my lord, may kindly have page 86, my lord, of the writ petition. On the strength of that order, my lord, we were told to amalgamate with the respondent, that school, my lord, 8 and 9. But we have our grievances, my lord, it has not been.
You served by Dusty then.
My lord, Dusty, my lord, in fact, my lord, they refused to take in the main writ petition also. In the main writ petition, I filed one Dusty.
Mr. Counsel,
Yes.
you make an attempt. If they don't accept it, file an affidavit saying that you made an attempt, but they have refused. Then we'll pass necessary orders.
My lord, till then, my lord, the meal at least. Midday meal. Not pressing for the other prayer, my lord. Since my respected senior.
Who is for midday meal?
SSM.
Who is giving midday meal? What is your instruction?
Lordship, the midday meal, the nodal officer is the deputy commissioner. As per requirement of the district, SSA only gives the fund to the district commissioner, and thereafter the district commissioner distributes among the number of school that is within the district.
And you are there, Mr. Pegu, for district commissioner? This is not a party?
DC is a party. DC.
Let me get the instruction.
All right. Office note date, no, Lavazima court's order dated 20/2/2026 indicates that notice has not been served upon respondent numbers 8 and 9. The details of the Lavazima court's order may not be required to be recited in this order. Petitioner applicant is allowed to serve notice to respondent numbers 8 and 9 by way of Dusty within 10 days from today. The applicant / petitioner shall thereafter file an affidavit to show proof of service. Top. Counsel for the applicant submits that the application is filed seeking stay of the order dated 31/2023 passed by the Director of Elementary Education. Whereby the petitioner school was amalgamated with the respondent number 8 school, pending disposal of the writ petition. Stop. Secondly, the applicant has also prayed for restoration of midday meal, which was provided to the students of the petitioner school, and which has been stopped as of now. Stop. Mr. B. Chaudhary, Learned Standing Counsel, SSA, submits that midday meal is distributed under the authorization of the district commissioner concerned. considering the same, Mr. G. Pegu, learned government, additional senior government advocate shall obtain instructions as to whether midday meal can be continued to be given to the petitioner school pending disposal of the writ petition by the next date. List again on so and so.
I'm so obliged, my lord.
Hmm.
Wait, please, your lordship.
52.
My lord, these petitioners,
Hmm.
they filed the writ petition basically praying for, my lord, regularization of their services.
Yes.
Now, while the matter is pending, my lord,
Hmm.
now, an order has been issued by the government, my lord, whereby a direction has been issued for release of all this ad hoc and contract employees.
Hmm.
When court is in session of the matter, state has filed the affidavit in the main case, they are not supposed to take such a measure, my lord.
How many
Lordship,
petitioners? How many petitioners are there?
9 petitioners.
And they are working as what?
Ad hoc contractual lecturers, my lord.
Lecturers where?
Yes. I mean, in fact, they were appointed, my lord, between 2010 and 2015.
Where are they working?
Different colleges of Assam.
Colleges.
In fact, my lord, their cases were forwarded by the Directorate for Regularization also.
Hmm.
If your lordships would kindly take the writ petition for a moment.
Is it because of that net slate and all that?
Yes.
They are
No,
refusing.
not because of net slate. Now, it is not, we fulfill all the requirements, my lord.
Hmm.
In fact, if your lordship kindly comes to page 20 of the writ petition,
Hmm.
this was by my lord education advisor to the government. After perusal of your letter, I have the view that there are either 2 or 3 options for the matter. Near regularization, fixed pay, or regularization. Near regularization and regularization would require fulfillment of UGC criteria like minimum marks. In addition, vacancy position of the colleges would also come into the picture. If they're advertised fresh, the said 3 number of candidates would not be able to compete with the fresh candidates. As your kind self is aware, recently cabinet has granted monthly remuneration of 55,000 to assistant professor working on fixed pay in the provincialized colleges. In view of above, the same may also perhaps be given to the 73 number of candidates. So at one point of time, my lord, this was the view expressed by the education advisor to the government of Assam. Then, my lord, if your lordship would kindly come to page number 21. That's not very important, my lord. That was by the president of the college. Yes. Now please come to page 25. In fact, the process to, my lord, regularize their services was started. Page 25.
Hmm.
This is a communication by the additional secretary to the director. With reference to the subject cited above, I am directed to request you to furnish the following information as discussed in the meeting held on so-and-so in the office of Chamber of the Secretary Higher Education. Appointment letter, net slate position, student teachers ratio, enrollment, existing faculty, justification, existing vacancy, etc. So, my lord, this is how the matter was going on. So, this while the matter was pending, my lord, now this communication has been issued, which your lordships will get in the IA, which we have filed, my lord, 1328. Lordship, page number 18.
Hmm.
Page number 18, it's a communication dated 17th of April, my lord.
Hmm.
With reference to the subject cited above, it is hereby reiterated that no provincialized college, government college shall engage any person, whether teaching or non-teaching staff against non-existing, non-sanctioned post under any circumstances. It has further been brought to the notice of the undersigned that certain institutions have engaged personnel on a contract or ad hoc basis in both teaching and non-teaching categories without obtaining prior sanction and in contravention of the applicable statutory provision, rules and executive instruction. Subsequently, a number of such contractual appointees have approached court seeking regularization of their services, leading to legal complications and administrative challenges for institutions concerned. In view of the above, and in order to avoid future litigation and ensure adherence to the established recruitment norms and procedure, all concerned are hereby directed to refrain from engaging any teaching or non-teaching staff on a contractual basis with immediate effect. Well, not so far so good. Prospectively, you don't appoint, we have no problem. Now, this is important. Further, in any case, in case any contractual staff is presently engaged in the institution, must take necessary step to discontinue such engagement in accordance with the applicable rules and contractual terms, ensuring that due process is followed. So, my lord, we are concerned about this part of this communication. So, my lord, my prayer is, my lord, that I am not praying for a stay of this communication, my lord. All that I pray for at this stage is status quo regarding our services be maintained during the pendency of the writ petition.
Yes.
And if your lordship would kindly have a look at order dated 6/1/26, my lord.
In the writ petition.
My lord.
In the writ petition.
No, no, in the IA we have annexed that order, my lord. Page number 15. In one of the division bench case, my lord, not in exactly similar case, but in somewhat similar case, my lord, the division bench has taken a view against the petitioners. There, my lord, a matter is pending before the Supreme Court. It is submitted at the bar that against the decision of the division bench of this court in writ appeal number so-and-so involving similar issue to one arising in the present proceeding, appeals were filed before the Supreme Court. The said appeals are presently pending consideration before the Honorable Supreme Court. Accordingly, the registry is directed to list the matter again on after 4 weeks. Parties are at liberty to make a mention for listing of the matter.
So any updates,
The Supreme Court order is next page, Miller.
any development?
Yes. The matter is pending, Miller. Now by order dated 25/2/25, Miller, the matter has been fixed on 19/5.
I think order date is 23/2/26.
No, Miller. No. Yes.
23/2/26
No, Miller. There, 28
Of
for
the-
there is latest order, Miller.
of the Supreme Court.
Yes. Same matter.
Where is it?
This is the order, Miller. Towards the bottom of the first page, 28/4/26. These matters were called on for hearing today. Upon hearing, the court make the following order list again on 19/5/26. My only submission is, Miller, since this honorable court is in session of the matter, in any case, the executive should not, Miller, make an parallel inquiry. Now, if your lordship would kindly have this judgment in Miller Akadas Ali, where a division bench of the honorable court says, Miller. Please come to para 15, Miller.
Yes.
When the court is in session of the matter, an administrative authority cannot start a parallel proceeding on the same very subject matter at its own ipse dixit and record a finding on the issues. If such an action is taken, same will amount to directly interfering with the dispensation of justice by courts of law. We have no hesitation to hold that the Eastern Register of Cooperative Societies clearly transgressed his authority in venturing into double in a matter which is sub judice before this court. Clearly, that this is an instance of an authority trying to overreach the orders of the court. The order dated being patently illegal and without jurisdiction, findings recorded in the said order are of no consequence. So, one of the principle is, my lord, when court is in session of the matter, normally administrative authorities are not supposed to undertake a parallel exercise. Now, my lord, admittedly, our cases were recommended, it was being processed, and the matter is pending, my lord. Now, at this stage, if this order is given effect to, well, so far as prospective application of the directive contained in the letter is concerned, we have got nothing to say. But question is, my lord, since we are serving since 2010 and now we are in 2026, in view of the latest judgment of the Supreme Court in so many cases, my lord, Dharam Singh, then my lord Sripal, then my lord Jago, then my lord Sripal is there. In view of this decision, my lord, where the Honorable Supreme Court has taken the view that these are all exploitative appointments. Therefore, you should not take advantage of the persons who have got no bargaining power. Therefore, my only prayer at this stage is, my lord, status quo as regards our services should be maintained.
All right. Yes, what do you say?
Lordship,
No.
Mr. K. Gogol will appear, Lordship, so he will make his submission after some time, Lordship.
After some time,
Because, Lordship,
where is he?
Lordship is appearing online in the Supreme Court case matter. Lordship.
Online, Supreme Court. In which case? Connected case?
Some other matter, Lordship. So after some time, Lordship, he will make his submissions.
Please write down. Heard Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by Mr. S. Das, for the applicants, public writ petitioners, who submits that by filing this application, the applicants pray for the direction to the respondents to maintain status quo insofar as their service is concerned, pending disposal of the writ petition. Next para. The case of the petitioners, public applicants, is that they were engaged in different provincialized colleges across the state of Assam as assistant professors on contractual basis. Stop. Although some steps were taken for provincialization of their services, but since the same has not yielded any result, they are before this court seeking a direction to the respondent authorities concerned to finalize the process of their regularization, public provincialization. Stop. Mr. K.N. Chaudhary, Learned Senior Counsel, submits that the the applicants have been working as such since the year
2010. Between 2010 and 15, they were appointed.
2010. And therefore, while the court is in session with the matter, with the issue, the Commissioner and Secretary to the Government of Assam, Higher Education Department, provide communication dated 17/4/2026, has instructed all the principals of provincialized college to take steps for disengagement of all contractual appointees. In accordance with the applicable rules and contractual terms. Stop. The learned senior counsel submits that. Since the court is, since the issue is under consideration by this court, the respondent authority concerned ought not to have issued the same. Stop. In this connection, the learned senior counsel has cites the division bench judgment of this court in Das Ali versus State of Assam and others, reported in 2014, 4 GLT 55. More particularly, paragraph 15 of the said judgment, wherein the division bench observed that when the court is in session of a matter, the administrative authority cannot start a parallel proceeding on the very same subject at its own ipsi dixit and record a finding on the issues. And the same will amount to directly interfering with the dispensation of justice by the courts of law. Accordingly, any order passed would be of no consequence. Next, the learned senior counsel further submits that a similar issue was taken up by a similar issue was negated by division bench of this court, and the aggrieved party has approached the apex court, and the same is still pending as on date. Now he submits that as per the order dated 28/4/2026, passed in SLPC number 7368 of 2025, the Honorable Apex Court has fixed the matter on 19/5/2026. Stop. Therefore, the finding of this court on similar issue is yet to attain finality, and therefore, pending consideration of the SLP as well as the connected writ petition, respondents may be directed to maintain status quo insofar as the services of the petitioners are concerned.
Yes, sir.
After some time.
Yes.
Time being, huh?
1935.
This is item number 52. Okay. You type that 52, the second part you take. Hmm.
Lord, in contempt petition, my lord, they have already submitted their affidavit. They have taken a stand that, my lord, prompt action will be taken for compliance of the order.
Sorry?
Prompt action will be taken for for
Prompt
compliance.
action.
Yes, madam. Now. My lord, I know.
Now somebody is supposed to appear.
Lordship, I'll be there. Lordship, I'd like to place the instructions, your Lordship.
Yes, what does it say?
Lordship.
Writ appeal.
Point number 3, your Lordship.
Writ appeal is not yet born.
Yes, your Lordship.
Then?
They have asked us to file the writ appeal, but we have not filed a writ appeal, your Lordship.
But is that the answer
No.
against a contempt notice?
Yes. And earlier also, my lord, they have preferred and writ appeal against the order passed by the Lord and single
Yeah.
judge. That was dismissed. Thereafter, they have preferred and review application also.
We had,
That was also dismissed.
In which case?
This case.
Same case.
Yes,
Then how do they file a second writ appeal now then?
I don't know that. Here, I go to check. Against the order passed by the Lord and single judge.
Lordship,
I have also enclosed this.
As my knowledge goes, Your Lordship, we had filed a review and that review was dismissed, Your Lordship. And now,
Now writ
there's
appeal.
instruction that we are.
Now writ appeal.
My lord, lordship kindly look into my lord, page 17, my lord, of my contempt petition.
Okay, first thing first, let us understand what is the order passed by this court.
Lordship,
Where is that page number?
page number 9, my lord.
9. WPC 5914.
Yes, my lord.
What was the direction?
My lord, if lordship may kindly come to my lord, page 15, my lord, operative question.
Please read.
My lord, here are 15. In view of the above, the judgment and order dated 31/8/2016 in WPC number 4053/2013 would hold its force, and the provision thereof that for the purpose of provincialization of assistant teachers science, the basis would be seniority and not the subject combination would also have to be followed. In the event the said proposition is followed, the petitioner is senior to the respondent number 6 in the manner as indicated above. If being so, the court is of the view that the order of provincializing the service of the respondent number 6 would have to be declared to be contrary to the requirement of section 4 of the Act of 2011. Having declared so, it is directed that the Director of Secondary Education, Assam, would pass a necessary order thereto by taking into consideration that the petitioner is senior to the respondent number 6. And being senior, the provision of section 4 of the Act 2011 would be applicable in favor of the petitioner. In doing so, the director shall follow necessary procedure under the law as required. While dealing with the respondent number 6, it is further provided that in the event the provincialization of the respondent number 6 is withdrawn, the benefits that had already been accrued to him shall not be recalled. And further, the case of the respondent number 6 be again considered under the provision of section 13(6) of the Act of 2017. Writ petition is allowed to the above extent. The aforesaid excel shall be completed within a period of 6 months. My lord, thereafter, respondent number 6 has preferred a writ appeal against the particular. Next page, my lord. Page 17.
Kishore Kumar Deka,
Lordship, this is the respondent number.
number 6. Then what has happened to the
That was dismissed, ma'am.
dismissed?
Yes. There are 27, if lordship may kindly.
27.
Yes.
Page 27.
My lord.
Then
Thereafter, my lord, they have preferred a review application against the order passed by the learned single judge. In the year 2024, after a lapse of 6 years, my lord, and that review application was rejected.
where is that?
Lordship, I have the word.
It is not available in the file.
No, my lord. In contempt petition, it is not.
Contempt petition not available.
Because contempt petition was filed in the year 2021. They have preferred the review application in the year 2024.
No, I understand. By way of
It is-
affidavit, you could have filed it. It's not there.
It is not there, but I have the
Give me a copy. Yes, what do you say, Mr. Mustahari? You are also there in
my lord.
that review.
And
You
my
had
lord,
appeared.
after dismissal of the review petition, my lord, they have filed their affidavit also. In their affidavit, my lord, if lordship may kindly come to para 5, lordship.
Page,
Page 3, my lord.
affidavit,
Yes.
page 3. No
In
running
contempt
page.
petition, in contempt petition.
It's not a running page.
Oh, sorry, my lord, page 30.
Filed by respondent number 5,
Yes, ma'am.
page 30.
Page 30, para 5.
Yes.
Now, how, my lord, same, my lord, they will prefer and retype.
Please write. Art Mr.
Yes, Chaudhary.
S. Chaudhary, learned counsel for the petitioner, who submits that the instant contempt petition is filed for non-compliance of the court's direction rendered by judgment dated 28/11/2018, passed in WPC number 5914 of 2014. Stop. Referring to the operative portion of the judgment, which is at paragraph number 15 and 16, the learned counsel submits that this court came to a finding that for the purpose of provincialization of assistant teacher science, the basis would be seniority and not subject combination. Stop. This finding was on the basis of an earlier decision rendered by this court, white judgment and order dated 31/8/2016 in WPC number 4053 of 2013. Stop. Accordingly, the petitioner was found to be senior to respondent number 6, and the benefit of provincialization was directed to be given to petitioners, he or she,
She, my lord.
to her. So insofar as respondent number 6 was concerned, upon the withdrawal of his or her. Respondent number 6,
He, my lord.
his provincialization his case may be considered again under the provisions of section 13(6) of the what is the full form of this Act of 17?
So it is,
Hmm?
2017.
Of the Assam Education, open bracket, provincialization of services of teachers and reorganization of educational institutions. Close bracket, Act, 2017, bracket, Act of 2017, close bracket. Stop. This court had also provided a time frame of 6 months for completion of the process, as was directed. Stop. Next para, aggrieved. The private respondent number 6 filed writ appeal number 28 of 2019. But the same came to be dismissed by the division bench by judgment and order dated 4/3/2021. Stop. After the dismissal of the writ appeal, the Department of School Education referred review petition number 166 of 2024. Seeking review of the judgment dated 28/11/2018, passed in WPC number 5914 of 2014. Stop. The review court was not impressed with the review petition and accordingly dismissed the review petition by imposing cost of rupees 20,000. Stop. Today, Miss
P. Musari.
B. Musari, learned counsel, appearing for the
Second, respond number 5.
respondent number 5, has produced a letter dated, what is the date? 8/4/2026, written to the Senior Standing Counsel, Department of School Education, by the Secretary to the Government of Assam, Department of School Education, asking the latter to prefer a writ appeal against the judgment and order dated 28/11/2018, passed in WPC number 5914, which is the judgment and order alleged to have not been complied with by the respondents. So this court has already noted the fact that The writ appeal preferred by the private respondent number 6 in the writ petition has been dismissed by the division bench of this court. And likewise, the review petition filed by the department has also been dismissed with cost. Stop. It is therefore not understood as to how such an instruction has come from the Secretary to the Government of Assam, Department of School Education. Is he a respondent here? Who are the respondents here?
In a contempt.
5.
Contempt is a commissioner, sir.
He's the respondent number 5. No, is he a party here?
No, my lord. Secretary, yes, my
Hmm? Ms. Musahari, you said you are
lord.
by respondent number 5. Did you say respondent number 5?
5, your lordship. Stop now, go.
But there is no 5. Hmm? You are appearing for which respondent?
For 9, 4, your lordship.
Hmm?
Respond number 5. This is-
But is he pleaded?
Just take, lordship, I'll just check the list. I'll respond number 5. Later on.
Correct, 9 crore convert. He's there.
He was implemented later on, I think.
No, he's there.
Yes.
Cost title also is there now.
Yes.
Lordship.
But this letter is written by somebody else. There's a change of hands.
No, your lordship, he is the one.
Then who is this Shah Nawaz Chaudhary?
He is,
You have 2 secretaries for Department of School Education.
he must be the deputy secretary, lordship, I'll just confirm. Because, secretary to the government of Assam.
Then you write. The secretary to the government of Assam, it's Department of School Education. Therefore, appears to be either not aware with the earlier proceedings in the writ appeal and in the review petition, or is not aware. as to how proceedings are conducted before the court. Stop. Ms. D. Musari, learned counsel appearing for respondent number 5, shall obtain appropriate instructions by the next date. Failing which, court shall pass consequential orders. List again on page 6. One more line, the communication dated 8/4/2026, produced by Ms. D. Musari, learned counsel, shall be retained in the record and marked as X for identification. Just staple this, okay? This is not together.
Development.
Right.
Permission item 9.
May I, my lord, this is regarding provincialization of service of the prisoners. My lord. My lord, the.
No, just a minute. You give me that file again once more. Just a minute. 1 minute. You have this somewhere, okay? It is also noticed that in the affidavit filed by the respondent number 5, more particularly at paragraph number 5 and 6, it is stated that steps are being taken to examine the matter and to place the same before the department for taking appropriate steps in accordance with law. If required for further provincialization in compliance with the order of this court. Stop. The Director of Secondary Education was also asked to deposit cost of rupees 20,000 before the before the Gauhati High Court Legal Service Authority bracket committee, okay, in compliance of the order passed in the review petition. To stop. Therefore, the communication produced by Ms. D. Musari appears to be contradictory to the stand already taken by respondent number 5 in the said affidavit. Yes.
Lord, as per last order, my lord, they are supposed to file affidavit, my lord. This is regarding provincialization service of the prisoners, my lord.
Yes.
My lord, they are the other staffs of the school, my lord. Their services were provincialized. Only these 4 persons were left out, my lord.
Yes. Matter of 2022. When are you going to file?
Your lordship, 2 weeks time may be granted already. Communication has already been made, your lordship, in this regard, your
My
lordship.
lord,
2 weeks time, last chance.
regarding the issue, my lord, there are other orders are similar orders are there, my lord.
What is your prayer? Provincialization.
Yes, my lord. Yes, sir.
He's right. By filing this writ petition, the petitioner prays for provincialization of his service as tutor of the postgraduate teacher under the provisions of the Assam Education, open bracket, provincialization of services of teachers and reorganization of educational institutions, close bracket, Act, 2017, as amended. Stop. Although the writ petition was filed in the year 2022, there is no response from the respondents
Lordship.
till date. Several opportunities were granted to the respondents, but as already stated, no affidavit is forthcoming till date.
Your Lordship, I would like, one instruction has received, Your Lordship. I would like to, Your Lordship, stated one statement, Your Lordship, that Your Lordship, ASSEB, Your Lordship, one direction has been, Your Lordship, needed, Your Lordship, pertaining to that report is still awaited. So for that, Your Lordship, we are not able to give the proper detailed report. DAC is not able to give proper detailed report because one instruction has been sought to from ASSEB, Your Lordship. That instruction is still pending, Your Lordship.
By whom?
Still not,
Instruction has been sought by whom? From whom?
Your Lordship, by DAC, Your Lordship.
From?
From DAC, Your Lordship,
By?
to ASSEB, Your Lordship. Education Board, Your Lordship, SEBA, Your Lordship. That instruction is still awaited.
The director has sought from ASSP.
Regarding the students who appeared in
Please-
HS.
Please listen, please listen. The director of secondary education has sought information from the ASSEB. By which letter?
Your Lordship, I will give Your Lordship. Some time may be granted, Your Lordship. I will produce that later, Your Lordship.
Not sometime, we'll give you last chance. That's all.
No, Your Lordship, I will produce it today itself, Your Lordship.
You
that
produce no
later.
problem, but I'll give you last chance.
Yes, Your Lordship.
You don't file, we'll proceed.
Instruction to this.
Matter of 2022. You don't want to file affidavit. It appears.
Lordship, that instruction will be needed, Your Lordship. How many students?
So at least file one affidavit saying that this is the thing which we have
Yes.
as of now. And in fact, instruction are complete. We need some more time
Yes, sir.
because of this reason.
Yes, sir.
That should be indicated. Do not delay the matter like that.
Yes, sir. I'm extremely sorry, Your Lordship.
Ms. P. Das, Learned Standing Council, Second Education Department, submits that some information was sought by the Director of Secondary Education from the ASSEB. And since the same is not yet received, a response could not be made to the writ petition. Stop. Even if that, if such is the reason, the respondents at least ought to have filed an affidavit informing the difficulties in giving a concrete response by filing an affidavit. Stop. Therefore, the submission made in absence of any affidavit cannot be accepted by this court. As a last chance, the respondents are granted 3 weeks' time to come up with their counter affidavit, failing which it will be understood that there is no response from them. List again. 2-6.
Obliged.
I'm deeply obliged.
May please, Your Lordship.
My lord, this case, my lord, is a my lord non-payment of my lord gratuity amount to the husband of the petitioner, my lord. He died in the year 2021, my lord. What happened, my lord? There was a my lord. There's a decision of the managing committee of the school, Kasar High School, to divert a fund regarding due to some urgent need of the school. The school building had to be repaired, so some amount was diverted from the my lord that separate fund to this fund, my lord, and audit objections raised, and the husband of the petitioner, my lord, died. Thereafter, the gratuity amount was withheld. Now, the director, that auditor, my lord, has clarified the matter at Annexure 18, page 6, your lordship. Kindly see, my lord.
Page 18.
Page 18. Is a third paragraph, my lord.
Yes.
May I read it, your lordship?
Yes.
At the same time, from records and correspondence of the school authority, it was also evident that all the relevant utilization records for expenditure of so-and-so was available with the school authority, and thus it was not at all a matter of misappropriation. It was further revealed that the deceased H.M. late Chandra Kumar, whose death cum retirement gratuity is withheld from payment on account of unsettled audit objection of worth rupees 6,42,550, did not execute the decision of renovation and repair works independently, but it was an unanimous decision taken at the SMDC meeting dated so-and-so in presence of President, deceased HM, and 9 other SMDC members of the institution. Thus, the then President and all SMDC members of the institution are also jointly and severally responsible for the objectionable expenditure of rupees 6,42,550 with the deceased HM. Now, with this unanimous, because of the unanimous decision, my lord, I was made the scapegoat, and everybody was telling that I, my lord, made this payment, I made this diverted, I diverted the amount, my lord, from that fund to this fund, my lord. And now gratuity amount has been withheld, my lord. There was no proceeding, nothing, because it is not a matter of misappropriation. Just it's a matter of, my lord, fund transfer, my lord. And the present headmistress, my lord, issued a letter to the director, my lord, requesting a post facto approval for that amount, my lord. But till then, nothing has been done. The director also has filed an affidavit, my lord. This affidavit,
This letter is issued by the
auditor.
auditor.
Yes, your lordship. That was also forwarded by the present headmistress to the, my lord, director, my lord. And director in his affidavit, my lord, all just simply say, due to non-completion and non-submission of audit settlement report along with non-liability certificate in respect to retired headmaster, the this year's amount could not be paid.
Where's the affidavit?
Affidavit, your lordship.
Respondent number?
Respondent number, my lord, the 3.
3.
Yes, sir, it was fine.
We have filed the affidavit yesterday only, man. So we have filed this affidavit yesterday only.
Respondent number 3.
Yes, madam. So it may not be taken with the record, madam.
Okay, Mr. U. Sharma, learned standing counsel.
Secondary.
Secondary education submits that respondent number 3 filed affidavit yesterday. To stop, it is seen that the affidavit is not yet on record. Office to verify and tag the same with the record. Can we have it early? List again on so and so. Before that. List again on 25/5. On which date an attempt shall be made to dispose of the case?
May I please, your lordship?
Yes.
Lord, this is a matter, my lord, wherein the petitioners institution, my lord, is a religiously, my lord, privately managed minority institution, my lord, named as a Nizamia Alia Madrasa, my lord. Has the protection under Article 29 and 30 of the Constitution of India, my lord. My lord, what has happened, my lord? We are challenging an order impugned in this petition, my lord. May be pleased to find the same is at page 57, my lord.
57.
My lord, page number 57, annexure 7 to my petition, my lord. My lord, this is an order issued long back on 2022. I am just reading the relevant part, my lord. In pursuance of the government office memorandum communicated wide number dated so and subsequently as per approval of the secondary education department, government of Assam wide letter number dated, the director of secondary education Assam is pleased to issue the order to merger of the following one high school with one high school of Hailakandi district under the Shiksha Kshetra. The details of the schools are mentioned in Annexure A and B. Now, my lord, here is an school where it has happened. This Bolipar High School is being amalgamated with ICMC High School. My lord may have found that in the bracket, there is a mention of senior madrasa, my lord. My lord, what has happened? This Bolipar High School was earlier is a senior madrasa, my lord. My lordship knows, my lord, that the madrasa education system in our state was prevailing, my lord, before these were converted into high schools, my lord, by way of an institutes. Now, my lord, what has happened in this senior madrasa, my lord, there are, my lord, two streams of educations were being, my lord, fused, incorporated, my lord, that is upper primary and high schools. Now, there is another institution was imparting, that is private, my lord, who has no nexus with the, my lord, government run institution. It was a purely private in the same area, my lord, in the same boundary and the land wherein, my lord, this Bolipar Nizamiya Alia Madrasa was functioning, my lord. In fact, the land of this Bolipar High School or Senior Madrasa was also operating, my lord, from the land of this, my lord, Bolipar Nizamiya Alia Madrasa. On, my lord, just on a charitable purpose, my lord. They do not have any own land on their on behalf, my lord. So this Bolipar Nizamiya Alia Madrasa, which was a, my lord, purely private, was never disturbed by the government, was functioning. But, my lord, when this madrasa education system had been recalled and repealed, and this amalgamation exercise had been carried out, then, my lord, may kindly turn to this clause 9 is now, my lord, disturbing us, my lord.
No, you have been amalgamated with ICMC.
No, my lord, this ICMC school had been amalgamated with this Bolipar High School and ICMC High School. This Bolipar High School was initially senior madrasa, my lord. Now, after conversion, it had been renamed as an high school. So, my lord, we do not have any objection if this high school is amalgamated with this ICMC high school. But what has happened, my lord, by virtue of this amalgamation, our property, my lord, our land, our structure, my lord, infrastructure had also been used up by the government, my lord, which is not at all permissible because this is a Wakaf property, my lord. The land wherein, my lord, this Bolipar Nizamiya Alia Madrasa and this Bolipar High School had been established, my lord, is on a Wakaf property, my lord, which is not disputed. So, my lord, therefore, this clause 9 says, the movable and immovable property, documents, records of the amalgamated school shall be vested in the name of base new school. My lord, clause 9 I am reading, my lord.
I've
Now,
seen it. I've
my
seen
lord,
it.
yes, my lord.
So
Now,
the new base school will be ICMC.
ICMC school, my lord. As
Okay.
a result, my lord, the
Amalgamation, you have no problem.
we do not have
Only
any
the
objection.
property.
Only the property which belongs to Nizamiya Alia Madrasa, my lord, once it is in Wakaf property, my lordship knows the right, title and interest is vested with the Almighty, my lord. This is a religious faith and belief. Now, once Wakaf, my lord, it cannot be recalled, revoked or the transfer or alienate in any form, my lord. So, by virtue of this clause 9, what they are doing, now they wanted to take up the entire property of this privately managed institution also, my lord, which they cannot.
So you have challenged this clause 9.
Clause 9, my lord.
Okay.
Clause 9.
What is
That
the response? What is the response?
my lord, the response is that, my lord, one affidavit has been filed by the director secondary as well as by the board, my lord. I beg to draw my lordship's attention to the affidavit which has been filed, my lord, by the director of secondary education, my lord.
Who's that? Respondent number 5?
Yes, yes, my lord. The Mamata Huja is the director of secondary education.
No,
my lord.
5 is chief executive.
No, my lord. I am referring to the chief executive by the Wakaf board, my lord. I am referring to the affidavit filed by the director, my lord. Starts from page 77, my lord. Running page, my lord.
Page 77.
My lord. And I straight away, my lordships can peruse paragraph 6, my lord. May I read, my lord?
Yes.
That the deponent disputes the correctness in regard to the statement made in paragraph 2 of the writ petition and states that although the petitioner has claimed that erstwhile Boalipar Senior Madrasa has been occupying the land of the Wakaf property of the Nizamiya Alia Madrasa at village Boalipar Part 3 and Moza Boalipar Part 3 having quantum of land of 2 bigha 15 katha and 11 chatok, but did not specifically mention the surrounding boundary of the said land, and thereby the exact physical location of the land cannot be ascertained. Further, the petitioner has failed to submit any registration certificate regarding the Wakaf property of the Boalipar Madrasa, Boalipar Nizami Alia Madrasa from the Board of Wakaf or any other competent authority. Thus, the claim of the petitioner that the erstwhile Boalipar Senior Madrasa has been occupying Wakaf property of Nizami Alia Madrasa is baseless and without any merit. Now, to my lord counter this paragraph 6, my lord, I beg to my lordship, may
5 minutes.
my lord, please. My lord. Oilom.
Yes, Mr.
Yes, my lord, I was drawing my lordship's kind attention to paragraph 6, my lord, wherein their contention is that as this property had not been registered in the Wakaf board, so therefore the benefit of Wakaf property cannot be availed, my lord. That is their stand. Now, my lord, in another paragraph, paragraph 8, my lord, they have countered the paragraph 5 of our writ petition, wherein they have said that the statement made in paragraph 5 of the writ petition are denied. While denying the same, deponent respectfully states that the erstwhile Boalipar Senior Madrasa was established in the year 1960 in the category of Bhansar stage at village Boalipar Part 3 PS Hailakandi, and subsequently government had taken over the said madrasa under deficit system of grant in aid, and later the madrasa was provincialized with effect from 15/8/1994 under the provision of Assam Madrasa Education Provincialization Act of 1995 under the jurisdiction of the Director of Madrasa Education Assam. Further, as the enrollment of the said madrasa would sometime drastically decreases, the government decided to convert the said madrasa into high school and rename the madrasa as a Boalipar High School. Subsequently, the said high school was amalgamated with the nearest base school, namely ICMC High School, Boalipar, due to zero enrollment in the said institution. After the amalgamation, the school building of Boalipar High School is being utilized by the headmaster of so-and-so school for educational purposes, being the government property. Now, my lord, to this contention and to this arrangement, we do not have any objection, my lord, if the property or the land or the infrastructure, if belongs to, my lord, this Boalipar High School or the erstwhile senior madrasa, my lord. Our only contention, my lord, in this petition is that as this Boalipar High School or the Boalipar Senior Madrasa do not have land in their own name till date, my lord, they do not have land. The land where from this Boalipar High School or the Senior Madrasa had been operating, my lord, was on our land, my lord. That is the Nizami Alia Madrasa. Now, for that, my lord, I beg to draw my lordship's attention to, my lord, one of the vital annexure, my lord, which is annexure 1, which from it reflects, my lord, that the Wakaf property at page 31, my lord. This is a, my lord, very old record, my lord, we have carved out from Jamabandi copy, my lord, a official record, and we have typed it out the relevant part, my lord, annexure 1, page 31. Due to Wakaf, the person at serial number 6, that is the Mutuwali of Boalipar Madrasa, have land measuring 2 bigha, so and so in Dag number so and so, along with the person at serial number 2 is Montaz Ali, my lord. My lordship knows, my lord, that once there is an Wakaf, my lord, this Wakaf property is required to be managed by a Mutuwali, my lord. And that Mutuwali had been appointed at that relevant period of time was one Montaz Ali, my lord. So, my lord, to this document, neither the respondents, my lord, till date had denied that these are not Wakaf property, or this document they have not denied. Only their, my lord, allegation is that as this Wakaf property had not been registered under the, my lord, act, under the Wakaf Act of 1995, my lord, under the Board of Wakaf, so therefore the benefit, we cannot avail the benefit of the Wakaf property, my lord, which is absolutely is in contravention with the Wakaf Act of 1995, my lord. So therefore, my lord, the property now which they are now trying to, my lord, occupy by virtue of this amalgamation policy, my lord, we are not, my lord, against the amalgamation or any of the, my lord, merger policy, but only we said that our property should be excluded from the, my lord, purview of this, my lord, amalgamation exercise by way of clause 9, my lord. That is only our grievance, my lord. And the stand of the, my lord, Wakaf board is also by bringing by way of an affidavit, my lord. The same stand had been taken, it is not registered. So therefore, my lord, this property cannot be given the benefit, my lord. Now, my lord, if you go by the Wakaf Act of 1995, my lord.
Let us see, yes. Walk. Which provision?
My lord, I straight away back to draw my lordship's attention to, my lord, section 3R, my lord, which deals with the definition part, my lord. First of all, my lord, I beg to draw the provision of, my lord, the definition part, my lord. Beneficiary means, my lord, clause a person or subject for whose benefit a Wakaf is created and includes religious, pious and charitable object and any other object of any other objects of public utility sanctioned by the Muslim law. So, my lord, this beneficiary.
Where are you reading?
My lord, I am reading
Which provision?
section 3 part definition, my lord. Clause, section 3, clause A, my lord.
A.
My lord. In this act, unless the context otherwise requires my lord.
Yes,
My lord, got it, my lord?
yes.
My lord, beneficiary means a person or object for whose benefit a Wakaf is created and includes the religious, pious and charitable objects and any other objects of public utility sanctioned by the Muslim law. Now, my lord, my respectful submission in this regard, my lord, is that this Nizamiya, Boalipar Nizamiya Alia Madrasa had been created in a Wakaf property, my lord, for the purpose of religious, theological, my lord, to impart the religious and theological education to a particular community for a charitable purpose. So therefore, my lord, this come within the definition of the beneficiary for those persons, my lord, who wanted to take the benefit, this Nizamiya from this Nizamiya Alia Madrasa, my lord. Now, I again, my lord, draw my lordship's attention, my lord, to the provision of section 3I, my lord, Mutuali. Mutuali means any person appointed either verbally, my lord, even a, my lord, a written instrument is also not required, my lord, or under any deed or instrument by which a Wakaf has been created or by competent authority to be the Mutuali of a Wakaf and includes any person who is a Mutuali of a Wakaf by virtue of any custom or who is a Nayab Mutuali, Khadim, Mujawar, Sajjada Nashin, Amin or other person appointed by a Mutuali to perform the duties of a Mutuali and save as otherwise provided in this act, any person, committee or corporation for the time being managing or administering any Wakaf or Wakaf property. So, my lord, till date, this property had been, my lord, before this amalgamation or the other subsequent development, there was a Mutuali who is managing this Boalipar Nizamiya Alia Madrasa, my lord. Now, my lord, if we go by the other part, my lord, the Wakaf.
What is the duty of a Mutuali?
My lord, Mutuali is just like a manager, my lord.
Manager.
He take care of the entire property, my lord. Whom to, how to use and earning of that, my lord, from that property is required to be used for the charitable purposes only, my lord, not for any other purpose. For those things, my lord, he has been entrusted with this duty, my lord.
Mutuali is appointed for a work property.
Work, my lord. Mutuali is directly connected with a work, my lord.
Okay.
So now, my lord, we come to, my lord, this Wakaf. Now, my lord, I beg to draw, my lord, straight away to, my lord, clause R.
Yes.
Waqf means the permanent dedication by any person or any movable or immovable property for any purpose recognized by the Muslim law as pious, religious, or charitable and includes a Wakaf by user, but such Wakaf shall not cease to be a Wakaf by a reason only of the user having ceased, irrespective of the period of such seizure. My lord, I am pausing here for a moment, my lord. The law is such in strict appliance, my lord, that, my lord, if somebody do not use the property as a, my lord, Wakaf property, even then also, my lord, this my lord, the devotion of that property as a Wakaf property will not cease, my lord. Now here is a case, my lord, from the date of very inception, my lord, when this Wakaf had been created in the name of the Nizamiya Alia Madrasa, my lord, is still operating till this impugn arrangement had been made, my lord. So therefore, this, if we go by the entire provision, my lord, the very purpose of the registration, my lord, is also not required, my lord, because by virtue of user, also, my lord, if a Wakaf property is being used from long, by virtue of the user by Wakaf, my lord, he can avail the benefit of this Wakaf property, my lord. Now, government cannot take up or take over this Wakaf property, my lord, by arbitrary, by often any policy decision of the government. Now, my lord, we do not have any objection, my lord, if both the high schools are being amalgamated. Only our prayer, my lord, is that the Wakaf property which belongs to the Boalipar Nizamiya Alia Madrasa should be excluded, my lord. That is our limited grievance and respectful submission before my lord, my lord.
Yes. Who's for the other side?
It pleases your lordship.
Yes.
Your lordship, regarding that land of the property, your lordship, we have stated in our affidavit in opposition, that is on page 78, paragraph 2 of the repetition, that has stated that he has claimed that erstwhile Bolipar Senior Madrasa has been occupying, that is very third line onwards. Petitioner has claimed onwards that erstwhile Bolipar Senior Madrasa has been occupying the land of the Wakaf property of Nizamiya Ali Madrasa at village Bolipara Part 3 and Mauza Bolipara Part 3, having quantum of land 2 bighas 15 katha 11 chatak. But he failed that specifically mention the surroundings boundary of the said land, that 2 bighas 15 katha 11 chatak, where he has mentioned the land, but he failed to mention the surroundings of the boundary of the land. Thereby, the exact physical location of the land cannot be ascertained. And moreover, your lordship, the petitioner has failed to submit any registration certificate regarding that Wakaf property of Bolipar Madrasa, Bolipar Nizamiya Ali Madrasa from the board of Wakaf or any other competent authority. Thus, the claim of the petitioner that erstwhile Bolipara Senior Madrasa has been occupying Wakaf property of Nizamiya Ali Madrasa is baseless and posing it without having any merit. And moreover, your lordship, page 79, regarding the act, your lordship, I would like to state it that erstwhile third line onwards, that the establishment of this senior madrasa year 1960 in the category of venture stage at village Bolipara part 3 PS Hailakandi, and subsequently government had taken over the said madrasa under deficit system of granting aid, and later the madrasa has provincialized with effect from 15/8/1994 under the provision of Assam Madrasa Education Provincialization Act 1995 under the jurisdiction of the Director of Madrasa Education Assam. Further, the enrollment of the said madrasa would sometimes drastically decrease. The government decided to convert the said madrasa into high school and renamed the madrasa as Bolipara High School. Subsequently, the said high school was amalgamated with the nearest based school, ICMC High School Bolipara, due to zero enrollment, no enrollment of the said institution. no enrollment was been seen, your lordship. And thereafter, your lordship, one nearby base school is there, namely as ICMC High School. It was amalgamated. After the amalgamation of the said building, the Bolipara High School is being utilized by the headmaster of ICMC High School for its educational purpose, being as a government property. And moreover, your lordship, in the affidavit, that is, they have made that paragraph 6 of the, we treat the same, your lordship. Further, the deponent respectfully state that erstwhile Bolipara Senior Madrasa was functioning under course curriculum of madrasa education as framed by Government of Assam Education Department. And from time to time, the course curriculum has been received and updated. Lastly, it followed the course curriculum of SEBA. And moreover, your lordship, paragraph 15 of page 18 of our affidavit, that it was amalgamated with nearest based school, namely ICMC. Already I have been submitted it, your lordship, and issued under the OM dated 3/8/2021. In the said OM office memorandum, that is on 5th line onwards, clause 19, it is specified that for any dispute arising out of the order of amalgamation, the aggrieved institution public may appeal. Continuation, page 18. Government in the secondary elementary education department, as the case may be, and also at clause 10 of the impugned order, which has already been passed at 29/3/2020, it is clearly stated that in case of any dispute, the OM which is issued on 3/8/2021, as well as the existing government rule and procedures shall be followed. Thus, when there is an alternative or effective remedy, the petitioner at the outset ought to have approached the appropriate authority, which is already been there in clause 19 of the OM issued on 3/8/2021.
What is that?
Already one, your lordship, OM has already been provided. Apni to listen, clause 19. Our petition of them. No, that's. Petition.
Where's the OM?
Your lordship, they have annexed it in the petitioner itself. I'm just 3/8/2021. It is on page 52 to 56, your lordship, in the said writ petition. Office memorandum, annexure 6, 52 onwards.
Are you referring to clause 19?
Yes, your lordship. Clause 19.
So was it approached? Have they approached the government?
19 is there, your lordship.
What is this part of OM?
Director. Your lordship, page 56. 19, director concerns.
No, I'm asking you the beginning.
Yes, your lordship.
What is this? Office memorandum
Office memorandum issued.
regarding what?
Your lordship, it was categorically, it was well existing government rule, and the procedure is, your lordship.
This is
And-
regarding a Shiksha Kshetra scheme, Milo.
Oh, it's-
Shiksha Kshetra scheme. Milo.
Shiksha Kshetra scheme for amalgamation and merger of different schools. So this remedy is also there in this scheme?
Yes, your lordship.
Milord, the remedy which has been, Milord, given the benefit is the disputed question of facts or something like if somebody is aggrieved by virtue of amalgamation or something like that. Here is a question, Milord, is regards the usurping of the property directly taken away by virtue of a, Milord, by violating the Wakaf Act as well as the other provisions, Milord. There is no any such disputes, Milord. Even we are not against the amalgamation also, Milord. We are, Milord, supporting the amalgamation. Let the high school be amalgamated with the senior madrasa.
So that we have understood.
My lord,
But thing is that it says for any disputes arising out of the
My lord.
order,
my lord,
the aggrieved institution, public,
my lord.
may appeal before the government in the secondary and elementary education department,
Yes.
as the case may be.
Now,
Now tell me one thing,
my lord,
this madrasa,
my lord,
Bualipar
Nizamia
Nizamia Alia Madrasa.
my lord,
Now, who was before this court is the, what is this, managing committee
managing committee, my lord,
of this madrasa.
my lord.
Now, madrasa is no longer there.
No, madrasa is there, my lord.
It is there.
We are there, my lord. We are, my lord, not the
The-
government institution, my lord.
Then what is this Bualipar High School?
My lord, what has happened, I am, my
This
lord,
is also another.
my lord, I am clarifying, my lord, what
Hmm.
has happened, my lord, initially,
Hmm.
this land has been, is a Wakaf property wherein this Bualipar Nizamia Alia Madrasa was created long back, my lord, in the year 1940s and 50s, my lord.
It's a madrasa.
Madrasa, purely privately managed, only to impart religious education, my lord, no
Then-
access with the government, my lord.
Then what about this senior madrasa?
Yes, my lord, I am coming, my lord. Then what has happened, my lord, this Bualipar, while it is functioning, my lord, another madrasa under the name of Bualipar Senior Madrasa had been established in our land, in the same Wakaf land. Now that senior madrasa subsequently, my lord, has been given the benefit of deficit system of grant and aid, and later on it had been, my lord, provincialized under the 1995 Act of the Assam Madrasa Education Provincialization Act of 1995, my lord.
That is what is written in the affidavit of
Exactly,
petition.
my lord. Exactly, my lord.
You
Now,
have written that.
my lord, just for a moment, my lord, I beg to draw my lordship's my lord, one important clause of this 1995 Act, my lord, which will automatically clarify the entire aspect, my lord. Section 10 of this 1995 Act, my lord. Yes, my lord, it is available in this manual at page 398, my lord.
This manual.
No, my lord, the education manual, this one. Asen niki log?
This one.
This, I am holding the bigger
The book
volume.
with the hammer.
My lord can find it on the Assam Madrasa Education.
Page.
Page in my book, it is in, starts at, my lord, page 392, and the relevant part which I want to draw my lordship's attention is at page 398, my lord. 919.
Section.
Section 10, my lord. Section 10, I am referring, my lord.
Vesting of land.
Vesting of land, building and other properties. The land, building or any other property owned by any senior madrasa, title madrasa or Arabic college whose employees service are provincialized as per provision of this act shall continue to be owned by the respective senior madrasa, title madrasa or Arabic college after such provincialization. My lord, may kindly see the even if the Milord madrasa of this Bualipar Senior Madrasa had been provincialized under this 1994 Act, but government has taken care, my lord, their land has never been, my lord, taken up by the government.
No,
Now,
that's okay.
my
But
lord.
here we are concerned with amalgamation,
That is correct, my lord.
not
Once,
provincialization.
exactly, my lord. No, my lord, amalgamation as a scheme, my lord, under the 1990, this
So
scheme,
amalgamation of two institutions into one.
my lord.
So they share the property. What is wrong in that?
No, my lord, they cannot. Because why they cannot? Because this amalgamation scheme is under a particular scheme, my lord, and wherein the land has already been forfeited by the government under this 1994 Act, my lord. Now they cannot take up a land which not belongs to them, my lord. This is a private land, my lord, which they, if they are required to take up the land, then, my lord, they have to go by the provision of the Land Acquisition Act also, my lord.
See, I think you should go to the government with
No,
this
my lord,
dispute.
the government, my lord, this is not a, my lord, a dispute, my lord. With my limited understanding, what I respectfully beg to submit, my lord, is that, my lord, already, my lord, we have this
If-
petition, my lordship
If
has
it
been
is, if
hearing.
it is not a dispute, then why read petition?
No, my lord, dispute is there.
Then
My lord,
dispute is there. So there is a mechanism provided in
My
the memorandum. So whatever you have to say, you go there and say,
No, my lord, what my respectful submission, my lord, in this
The-
regard is
the-
that, my lord.
the government or the department concerned will be in a better position to appreciate your case.
And moreover, your lordship, he stated one, your lordship, page 9 in his writ petition, that the paragraph 5 of his writ petition, that in the year 1963, the upper section of Baulipara Nizamia Alia Madrasa have been taken into the government deficient system of grant in aid, renamed as Boliapara Senior Madrasa. And here, your lordship, for provincialization, your lordship, land is the main, your lordship, ingredients, your lordship, to get the provincialization.
Where
your
is
lordship.
that? Where is that?
Your lordship, page 9, your lordship,
Of?
paragraph 5.
Nine-
He already, this, your lordship, matter, your lordship, in
9 of the writ
1963,
petition.
provincialization. Yes, your
Page
lordship.
9 of the writ
Page
petition.
9, paragraph 5.
Yes.
Writ petition.
My lord, that is correct. What my learned friend is referring, my lord, I am not disputing, my lord, that in the year, what I have just stated before, my lord, if I may be allowed to read, my lord, that in the year 1963, the upper section of the Boliapar Nizamiya Alia Madrasa had been taken into the government deficit system of grant in aid, renamed as Boliapar Senior Madrasa, and then the managing committee of Boliapar Nizamiya Alia Madrasa had allowed Boliapar Senior Madrasa to run its classes in the existing building of Boliapar Nizamiya Alia Madrasa. Now, my lord, just I am pausing for a moment, my lord. Here there were two sections, my lord. The part of the, my lord, upper part, Boliapar Nizamiya Alia Madrasa has been, upper section means, my lord, the high school part, my lord, which starts from class 8, had been, my lord, taken up by the government for the purpose of granting the deficit system of granting it. I have also annexed that order, my lord, just for a moment, my lord, if my lord may be pleased to take up that order, I have also made a part, my lord, is at page, my lord, 35, annexure 2. In partial modification of the earlier government notification number dated so and so, the governor of Assam is pleased to provincialize the number of 676 teaching and non-teaching employees of 42 senior title madrasas and Arabic colleges now covered by deficit system of granting aid with effect from 15/8/1994 as per list enclosed. So, my lord, this is the list of that madrasa. My lord, may be pleased to find our name is at serial number 9 at page 36, my lord. This is, my lord, Boliapar Senior Madrasa Post Office so and so. Herein what has happened, my lord? From class 8 to 12, upper section had been taken up by the government for the purpose of provincialization by leaving the property at the madrasa itself, but not taking up the property by virtue of section 10, my lord. So therefore, my lord, even after this institution had been provincialized, till date, this property is a private property, my lord. So now, my lord, what they are doing by virtue of this amalgamation, they are now wanted to use up, and my lord, by forcefully in an arbitrary manner wanted to take up the property of the Boliapar Nizamiya Alia Madrasa, my lord, which is not at all permissible, my lord. That is our, my lord, main contention of our writ petition, my lord. If my lord may be pleased to take up our prayer, my lord, what we have prayed in our petition, my lord, may be pleased to find. Lord, to set aside oblique was the impugn order, especially clause 9 of the impugn order by which the movable and immovable property had been acquired by the respondent in violation of the relevant law oblique laws, my lord. Now, my lord, this relevant law oblique laws also covers this 1994 Act as well as, my lord, this Wakaf Act of 1995, my lord. Secondly, my lord, to respondents to release land over the movable, immovable property of the Boliapar Nizamiya Alia Madrasa to the petitioner. We want our land back, my lord. This is a Wakaf property, my lord.
Your lordship, to that, your lordship,
Fine.
I am seriously objecting, and already we have stated in our affidavit in opposition, paragraph 6 of page 78, because he cannot ascertain, your lordship, the exact physical location of the land cannot be ascertained. I'm repeatedly stating that, and moreover, your lordship, he has failed to submit any registration certificate regarding Wakaf property of Boliapara Madrasa, Boliapar Nizamiya Alia Madrasa from the Board of Wakafs, and that is my claim, your lordship. He cannot claim just like that, your lordship, because he is not showing any documents to the competent authority. And before, your lordship, availing that office memorandum 19, your lordship, he filed this with petitions.
So Bhuya,
My lord, my lord,
see, you've been dealing with a lot of provincialization cases,
my lord,
correct?
my lord,
And one of the precondition is that you should have the school has to have a land,
my lord,
correct?
my lord. Yes, my lord.
It cannot be a land on rent or something like that. The school has to have a land. That is
No.
one of the condition for the provincialization.
No, my lord, I am not.
Now, in your case,
my lord.
school has been provincialized
Correct, my lord. Under
on the basis of that land.
Yes.
No, not on the basis of that land, that is correct, my lord. But
Then-
the government has, by virtue of this section 10, it has been provincialized with this condition only, my lord. This is not my statute. This is an statute created by my learned friend, my lord. Now they are submitting again the statutory prescription, my lord. My lord, may kindly peruse paragraph, section 10 again, my lord. I am troubling my lordship, my lord. Vesting of land, building and other properties. It is very clear, my lord, that the land, building or any other property owned by any senior madrasa, title madrasa or Arabic college whose employees' services are provincialized as per the provision of this act shall continue to be owned by the respective senior madrasa, title madrasa or Arabic college after such provincialization, my lord. So therefore, my lord, the property had never been acquired or taken over by the government, though a land is a condition, my lord. Without a land, no madrasa or institution, my lord, can be provincialized. That is admitted, my lord. But the land had not been taken. I have not finished. But the land had not been taken up by the government.
SP Das, you take your seat.
My-
We hear you.
My lord. No, I am not taking any
Mr.
undue
Mr.
advantage.
Bhuya is
from-
very patient.
No, my
So,
lord.
okay.
So therefore,
Now-
my lord, I'm sorry, my lord. Therefore, my lord, my respectful submission, my lord, is that, my lord, when the law is very clear and explicit, my lord, that the Wakaf property should be remain as a Wakaf property till, my lord, this cannot be revoked, alienate, or it can be donated to anybody, my lord. Now, what by virtue of this scheme and policy of this very, my lord, Shiksha Kshetra of the amalgamation, what they are doing by virtue of the clause 9 is now going to already taken over, not going to already taken over, used up our property, my lord, at the, my lord, grave of this, my lord, provincial, this scheme of amalgamation, my lord, which is not at all permissible, my lord.
These two institutions are nearby.
Different institution. One is private, one is a government institution, provincialized.
It's in a different parcel of land.
No, same parcel of land, my lord. This, if my learned friend, my lord,
No.
saying that,
How can it be same?
no, my lord, the land is same, my lord. Why I am submitting, my lord?
No.
This,
Listen, Mr.
my lord.
Bhuya,
My
what I'm saying is different. This ICMC high school is in different land.
Is a different land, madam.
And Bolipar High School, Senior Madrasa is in a different land.
In different land, but they do not have any own land. They are
They are not together, not conjoined, isn't it?
not conjoined, my lord. What is the
Separate.
separate? The exact, my lord, the geographical location is that land A belong to Boalipar Nizamiya Alia Madrasa and Boalipar Senior Madrasa. And land B belong to ICMC. We do not have any objection with the land of land B. Now, land A, my lord, Schedule A land belongs to the, my lord, these present petitioners. Even this Boalipar Senior Madrasa, they do not have any land in their name also, my lord.
Senior Madrasa is one thing and one is the
Nizamiya Alia, my lord.
Nizam Alia.
Alia.
These are two things.
Two things, my lord. Correct, my lord.
And the school, Senior Madrasa was running from that land.
Running from our land, this Wakaf property land, my lord. If my learned friend can show, my lord, that this is the land of Boalipar Senior Madrasa after provincialization, this is the schedule, this is the DAG number registered in the name of the Boalipar Senior Madrasa, then, my lord, we do not have any case. But, my lord, by virtue of the Jamabandi copy, my lord, we can demonstrate before my lordships, my lord, that
Yes.
we have a land. Yes,
What is this thing which you have just shown me?
yes,
Page
my lord.
31
Page 31 is a Jamabandi copy maintained by the Revenue Department, my lord.
in respect of?
In respect of land belong to, my lord, Boalipar Nizami Alia Madrasa, my lord.
Patada's name is Monta
No,
Chali.
he was the Motowali at that moment, my lord.
Monta Chali was the Motowali.
Motowali, my lord, appointed.
And what is the remarks? It says due to Wakaf.
My lord, due to Wakaf, the person at serial number 6, that is the Motowali of Boalipar Madrasa, have land. That means, my lord, as the land had been Wakaf by the original Wakafi, donated. So therefore, the name of, my lord, serial number 6, as by virtue of Motowali, had been recorded in the Jamabandi copy, my lord. That is my understanding, my lord. So therefore, my lord, the issue of remanding the matter before the government, my lord, is as the law involved, my lord, that whether a Wakaf property can be used up in this manner or not, my lord. I don't think, my lord, the government can decide by virtue of an appellate forum, my lord. My lordships can, my lord,
Can
examine.
we
the law.
decide by a writ petition also?
Yes, yes, my lord, because, my lord, because, my lord, when there is
See,
a.
you have made some averment, they have
Fine.
disputed that.
No,
So
no, my lord,
ultimately it
dispute-
becomes a disputed question.
No, my lord, the disputed question is not in respect of the facts, my lord, but the issue which we have raised, my lord, is by virtue of law only, my lord. That whether they have not disputed one thing, my lord, that this Nizami Alia Madrasa, the land which we have projected is not a Wakaf property. They have said that we could not demarcate the boundary, my lord. That is their issue. That's why if somebody cannot demarcate the boundary, that does not mean the Wakaf property will be waived, my lord, or it will be vaporized.
So for what purpose they using that land now?
That land now
For
they are
having
going to
classes.
use ICMC High School. They are now going to give it to ICMC High School, Milo.
No,
Already
they-
given, Milo.
No, they're using it for some class. That's what they
No,
say.
using for some class, but our institution has been restrained from operating, Milo. We cannot operate. Our property, our land, we are now being restrained from operating, Milo. Students are suffering, Milo.
See, the movable, unmovable property, documents, records of the amalgamated school shall vest in the name of the base new school.
Base school, Milo.
Now you say
Milo.
that this upper madrasa,
Up, Milo.
senior madrasa,
Senior madrasa, Milo.
does not have any property.
No, they have their building only, my lord, but they do not have the land. The building wherein this, building wherein this is structured, my lord,
So they will take the building, not the land.
not the land, my lord. Let the building be taken, let the movable property be taken up. We do not have any objection, my lord.
Question is whether this high school,
My lord.
Boilapar High School or senior madrasa has any land or not.
Any land or not. If they can demonstrate before my lord on the next date or if
Whether
my
they
lord,
have any land or not.
land or not,
So
my lord,
presumption is made that
Yes.
where the high school is standing is the land of that high school.
of that high school, my government.
You
even
say that that is not their land.
there is no land. It is our land, my lord. That is, there is no dispute as such, my lord.
So where is the material to show that it is not their land?
No, because they, in their affidavit, my lord, they could not demonstrate a single document, my lord, that.
Forget about them demonstrate. You demonstrate.
I have
that this is
demonstrated,
my
my lord. I have demonstrated, my lord, by virtue of the page 31, my lord. The Jamabandi copy land, my lord, this dag number, patta number, and the mention of the Wakaf property, my lord.
But Jamabandi is one thing, of course. See,
My lord.
this is
No, my lord, this Wakaf property has always been used in this manner, my lord. There was no
in a
dispute, my lord.
226 proceedings.
My-
Can we go into all these things?
No, we have to go, my lord, I have a very limited knowledge in respect of my lordships, my lord. This is an issue wherein, my lord, only the record which we have demonstrated by virtue of a Jamabandi copy, my lord. We do not have any other document at this moment, my lord. The government is not required, my lord.
That is why
My lord.
basically your stand is taken is projected through an affidavit.
No, my lord, it by virtue of this Jamabandi copy we have projected, my lord. This is an official record maintained by the revenue department, my lord. If my lord call for a report from the revenue also, it will also be clarified, my lord. That whether we have any land or
Who
not,
maintains this Jamabandi?
by the revenue department.
Revenue department.
My lord.
They are not a party here, revenue.
My lord, what if I no, no, my lord.
Lordship, before that, Lordship, may I draw a subject to?
Please.
The paragraph 2 of the writ petition, Lordship.
Yes, what is that?
He has given the DAC number and pata number of that plot of land which is claimed, Lordship. Lordship, DAC number is 439, 493, 494, 497, 948 of 2 bigha of land at Chatak land, which are given to work for establishment of Boalipar Madrasa. This was his claim. And the chief executive officer of the Assam Board of Work, Lordship, filed an affidavit.
As per paragraph 2.
Lordship. Affidavit.
Just a minute. You're saying as per paragraph 2.
Lordship. Paragraph 2 or writ petition.
Writ petition, paragraph 2.
Lordship. Page 7. Page 6 and 7.
Correct. This corresponds to annexure 1 only.
Yes, Lordship. Annexure 1, Lordship.
Then
It is statement. And now, Lordship, page 71.
what is 71?
71 is the affidavit in opposition filed by respondent of 5, the chief executive officer of the Assam Board of Work. Lordship.
Hmm,
Lordship got it?
71.
71.
Just a minute, the beginning is respondent number 5.
Yes, Lordship, beginning from 59.
Why respondent number 5 is a party?
He is the Chief Executive Officer, Assam
That
Board
I
of-
know, but why is he made a party?
who is the custodian of the work property, Lordship.
Okay. Okay, and you file affidavit.
Paragraph 5, page 71. Lordship.
Mr. Datta, you're appearing for which party?
Secondary part, secondary. I am assisting.
And you are relying upon affidavit of respondent number 5.
No, Lordship.
You have not filed affidavit.
He is appearing.
I know you are appearing, but he's referring to your affidavit.
Yes.
Where is your affidavit?
But I have, so we have also filed our affidavit. Lordship.
Okay. Anyway, let's see what you want to say.
Page 71, Lordship.
71, yes.
Paragraph 71.
Paragraph?
Paragraph 5.
Yes.
That with regard to the statement made in paragraph 2 of the writ petition of the deponent back to stated Madrasa name Nazamia Alia Madrasa Managing Committee covering dark number so and so so and so
Hmm. Yes.
of 2 bigha 15 katha 11 shatak is not found to be registered under the Assam Board of Work. However, a madrasa name Nizamia so and so being registration number 1502 is registered under Assam Board of Work. The said madrasa is located in Hailakandi village, Mohanpur part 1 so and so bearing dark number 252, pota number 72. As such, deponent back to submitted the mentioned dark number pota number in paragraph 2 of the writ petition appears to be defined from the registered madrasa. My humble submission before Lordship,
It says it's not registered.
registered.
If it's not registered, then it will not
How
be
can-
there.
It is not a work property.
Then, of course, if it's not registered, it will not be there.
Yeah.
Then why do you come up with this pata number 72 again?
No, it is.
Dark number so and so.
It is not registered before the work board of work. Lordship.
Hmm.
So it is not a work property as claimed by my petitioner, Lordship, my friend Lordship.
Without
So-
registration, it cannot be a work
No,
property.
Lordship.
Registration is a must
Lordship,
of the Work Act. What does it say?
Anyway, Lordship, my humble submission, I would like to give down that in this disputed question of fact, Lordship, can that petitioner be asserted before this honorary court, Lordship? Is it not the civil court is the proper forum to relegate all this matter and to decide?
That has occurred to the court also. That's why I had made that question. 36 is registration. No, do you tell me any provision here that without registration of work property, it cannot be considered as a work property? Is it?
Then the record. Currently, the petitioner only has the producer Jamabandi copy. Now, Jamabandi does not signify factor. So, whether to believe the work code maintain the record of the work property that are registered. If once the property is registered, once the property, even if gift as work, the Mutawali is required under the act to register it under the work code.
So without registration, it cannot be considered as a work property.
As per the, as per us, it is not there, that property does not exist as a work.
No, that understood. It is not there. It never registered it with you. But even if it's not registered, they say there is a work property, not registered.
Lord, it is Wakaf by.
Can it still be considered as a work property?
No. My learned friend is not correct, my lord. There is a provision of Wakaf. My lord, recently the Supreme Court has clarified. My lordship knows. My lord, this new Wakaf amendment had been put into challenge before the Honorable Apex Court, my lord. Wherein the Honorable Apex Court has clarified, my lord, that those properties which are, my lord, interim order is still operating, my lord, is used as a Wakaf by user. The registration is not mandatory at that relevant period of time because all these things have been discussed, my lord. If my lordship's, my lord, is not going to dispose of today, my lord, can fix some other day, my lord, I will clarify in this aspect also, my lord. Because that has a bearing in this case also, my lord, that judgment, my lord. My lord,
Yes, you produce it.
my lord. Because my learned friend has taken a stand that without registration, there cannot be Wakaf, my lord. That is not correct, my lord. I will satisfy my lord, my lord. These all things had been discussed, my lord.
Please, right? We'll have it some other day.
My lord.
Let
my
him
lord.
bring whatever. he has.
Only my prayer, my lord, can keep this as a part third, my lord.
No, not part hard.
My lord, so many time, my lordship is kind enough to given us, my lord.
No. See, part hard will get things stuck. And if you don't take too long a time, then definitely we can
My lord.
hear it again. Please, right? From the projection made by the petitioner. From the projection and claim made by the petitioner. The issue which arises amongst others is as to whether a property which is not registered under the Wakaf Act of 1995 can still be considered as a work property. Stop. The same has relevance in the instant case. Since the petitioner, who is the Gauhati Nizamia Alia
Alia
Madrasa Managing Committee, claims that the land in which the Gauhati High School (Senior Madrasa) is situated is a work property.
55.
And by issuance of the order dated 29/3/2022, Annex 7, more particularly at clause 9 of the said order, the movable/immovable property, documents, records, etc. of the amalgamated school cannot be vested upon the base school, that is the ICMC high school, since the property, since the land in which the senior madrasa is situated belongs to the Gauhati Nizami Alia Madrasa. Stop. Mr. A.R. Bhuya, learned senior counsel, submits that he may be given some time to produce an authority to show that registration is not compulsory
My lord.
to consider the property as a work property. This again. Okay.
My lord. Obliged, my lord, deeply obliged.
This was item number
13.
13. So remaining we have what? This was an admission matter, isn't it? Two admissions are there, then one finding. Morning, somebody had mentioned about some unlisted matter.
This one, my lord.
Unlisted motion?
I have mentioned.
You had
I
mentioned.
mentioned.
Okay, unlisted motion is there.
Yes. Wait.
Then that time being matter? Time being that 52 is there. The files have come unlisted. You just inquisition will give it to me. If the file comes, the unlisted will take first.
My lord.
Then I think we'll go for the time being matter 52. Somebody was supposed to appear. K. Gogoi, yes. You inform Mr. K. Gogoi. K. Gogoi, 52. Add to one unlisted motion is there. So after that, we take up this one.
Raj.
Yes, please, your lordship. Lordship, item number, hearing item number 42, 43, 44, and 45. May I pray for listing this matter on Thursday, lordship? Today some. Thank you, lordship.
Today is also Thursday.
Lordship,
Today is also Thursday.
Thursday next, 7th, on 7th.
I don't know. See, situation will be different. Which matters are you mentioning?
42, 43, 44, and 45 is a hearing item.
42 to 45.
Lordship,
What are these matters?
these are all lordship, pensionary benefit, claiming the petitioners are claiming the pensionary benefit. Otherwise, they are illegally.
Area salary and
lordship.
pensionary benefit.
So these are all,
You are up for the department.
lordship, I am for the elementary education department, lordship.
Why do you want adjournment?
There's some difficulty, lordship.
Difficulty.
Otherwise also I'm.
Okay. So P.N. Sharma, learned standing counsel in the Mediation Education Department, submits that he has some personal difficulty to conduct the case today. He prays for adjournment. We state prayers not opposed by the direct counsel for the decision. List the date.
9, 6, 9.
9 June for hearing.
9 June. 9 June.
Tuesday.
19. 9 June. June.
9 June for hearing. Okay. Yes. Call. Next. Yes, Mr. Bhuya.
May I please, as your lordship? My lord, in fact, in this petition, my lord, we have challenged a deployment order of a teacher, my lord. Now, first time, my lord, I have come to see such type of order deploying a teacher, my lord. Generally, deployment is for the army personnel or the defense personnel, my lord. My lord, may be pleased to find the order which we have challenged is at page 25, my lord.
Yes, I've seen it.
My lord, as per approval and my name, my lordship may be pleased to find Abdul Alim, assistant teacher of so-and-so school, has been transferred and has been deployed, my lord, in Vivekananda Vidya Higher Secondary School, Dipgoi. So, my lord, from
Where-
Vivekananda, I have been transferred to Sabitri TE Model Schools, my lord.
Where is
And-
this?
This is also in the same district, but my lord, nearly distance about 40 to 50 kilometers, my lord, at present. So every day ups and downs and very remote area, my lord, there is no provision of any proper transportation. It's a tea garden area, my lord. And my lord, why this order is not maintainable, my lord? I have, first of all, my lord, I beg to draw my lordship's attention, my lord, to my appointment order, my lord, at page 21, annexure 2, my lord.
Yes.
My lord, this is the order by which I had been appointed, my lord. I am just reading the relevant provision, my lord, in pursuance of the government approval for filling up of the vacancies of the graduate teachers, art, science, Hindi and Sanskrit, and I am a science teacher, my lord. And subject to discharge without notice and without assigning any reason thereof, the following candidates duly selected by the district selection committee and approved by the director of secondary education Assam, so and so are hereby temporarily appointed as a graduate teacher, art, science, Hindi, Sanskrit in the provincial secondary school in the so and so of, plus allowances as admissible as per rules with effect from the date of his her joining. And my name, my lordship may be pleased to find in the last of page 22, my lord, table, Abdul Alim, graduate teacher science, unreserved, my lord. So, my lord, this appointment order had been effected on 25/5/2023. And now, my lord, before this, my my lord, tenure of 3 years, suddenly, my lord, this order of deployment had been effect, my lord, and I had been deployed to so and so. Now, my lord, my ground for challenge of this transfer is that, my lord, already there is an statute. My lord, the government has come up with an statute for the purpose of transfer or the deployment. There is no provision of deployment actually, my lord. So now I have made a specific representation, my lord, by stating all these details before the inspector of schools to the, my lord, to rotate through the director of secondary education Assam as well as the principal. But my lord, they till date they have not acted upon to my representation also, my lord, and now they are forcing as well as, my lord, a so cause notice had also been issued just day before yesterday, my lord. My lord may be pleased to find that so cause notice is at page 29, my lord. So, my lord, in my representations, my lord, I have specifically, my lord, penned down all the details, my lord, that why this deployment order is not correct. But, my lord, they have not acted upon or taken any decision on my representation, but by issuing the so cause, the inspector of school has now yesterday visited the school also, my lord, and personally, my lord, pressurizing me to go and join in the deployed school, my lord. So, my lord, they can consider my representation with a reason order, my lord, and till this consideration, my lord, at least I may not be disturbed, my lord, that much interim order, my lord, I am only praying today, my lord. Or if my respected friend brings any instruction, my lord, on till Monday, my lord, should not be, my lord. And, my lord, I am a person of seriously medically ill, undergone surgery, my lord, for the 2 times, my lord. Those medical reports has also been submitted to the authority, my lord. My lord, my verbal instruction is that, my lord, if I do not go and join, my lord, then I may be again placed under suspension or a serious departmental proceeding they may initiate, my lord.
See one line here in the impugn order.
My lord, my lord.
They are directed to report and join on the day of inauguration.
Yes, yes, my lord. They are directed to report and join on the day of
When was the inauguration?
It has been, my lord, already as per my instruction is, my lord, this is an order. Second communication letter 13/2/2026 communication is there. Now, my lord, the school has already been joined, my lord, inaugurated. That's why, my lord, this order had been issued on 10/3/2026, my lord. Because, my lord, if we go by the, my lord, so cause notice, my lord may be pleased to find that so cause notice is at page 24, my lord.
Yes.
If, my lord, so cause notice, may I read, my lord? It has come to the notice of the undersigned that as per approval of the office of the DSC Assam Bhait letter number dated so and so, and this office Bhait order number dated so and so, you were deployed to the newly constructed model school, Savitri T model school, for its smooth functioning. However, it is observed that you have not joined your place of posting till date. The above action on your part constitute violation of the order of the higher authority. Such lapses are viewed as acts of gross negligence and insubordination, warranting strict departmental action under the existing rules and procedures. You are hereby directed to so cause within 3 days from the date of receipt of this notice as to why disciplinary action as per provision of the so and so Act of 1904, which the breach of conduct should not be initiated against you for failing which comply with the official deployment order. Now, my lord, responding to this so cause notice, I have again replied, my lord, is at page 30.
No, those I've seen.
My
So,
lord, my
yeah.
lord, my lord.
What I was just asking you was that it says that you are directed to report and join on the day of inauguration.
My lord, that has been
So
done.
some inauguration function was there.
Was there, my lord.
When was that? No
My
idea.
lord, that instruction I do not have, but
Okay.
from the so cause notice, my lord, they have, it can be presumed, my lord, that is.
Yes, who's appearing? Yes, Ms. Das, what do you say?
Span of time, your lordship, although, your lordship, I tried to bring the instruction, this matter, your lordship. But your lordship, I'm failed to obtain any kind of instruction from their ends, your lordship. So kindly matter may posted on Monday, your lordship,
Monday.
this Monday.
We can do that. See, there's an option, two options maybe. One is post on Monday, and second is we can also dispose saying that they consider the representation within a time frame. Until
Yes.
then, no effective, no, he should not be forced to join that much.
Presentation.
Your lordship, then there will be one kind of interim of
Yes, yes.
protection also there.
That some protection will have to be done because
That your lordship, I am just praying for Monday, your lordship. Monday, your lordship, matter me posted, your lordship. In the very meantime, your lordship, if I obtain instruction, I'll place it before before this vote, your lordship. On Monday. Meeting hai.
Fine. Tomorrow is a my lord holiday, their office may also be closed, my lord.
no, whether it's Monday or what, any day, we are saying that you don't take any
Coursive action.
coercive steps.
Well,
That's all.
Or Wednesday, my friend can, my lord, obtain also.
Heard Mr. A.R. Bhuyan, learned senior counsel, assisted by Mr. N.M. Majar Bhuyan, who submits that the petitioner is aggrieved with the order dated 10/3/2026 insofar as he is concerned. Stop, he submits that the petitioner has been deployed from the school where he is working, that is
Vivekananda.
Vivekananda Vidyalaya High Secondary School, Digboy,
Fine.
to Savitri TE Model School. Stop, he submits that as per the said order, petitioners to report and join on the day of the inauguration. And the posting is done by way of deployment, which is rather unusual. To stop, the learned counsel submits that, learned senior counsel submits that since the new school where he has been deployed is at a distance of about 40 kilometers from the place of his residence, and there is no proper transportation, coupled with the fact that the petition is also
Undergone surgery, my lord.
a person who has undergone surgery.
Hernia, my God.
To stop, the petitioner therefore submitted a presentation before the Inspector of Schools, Tinsukia District Circle, on 13/3/2026, requesting reconsideration of his deployment. But instead of considering the same, the respondent authorities concerned have issued a show cause notice to him on 27/4/2026. Requiring to show cause within 3 days from the date of receipt of the notice as to why disciplinary action should not be taken against him for not complying with the order of posting. Stop. The petitioner has also submitted his reply to the show cause notice on 29/4/2026. But as he apprehends that departmental proceeding will be drawn against him without considering his representation, the petition is before this court. Ms. P. Das, Leonard's Standing Counsel, Second Litigation Department, submits that since the matter has been taken up as an unlisted motion today, she would require some time to get instructions in the matter. Stop as paid for, let the matter be listed. Wednesday? On 6/5/2026. An extra copy of the writ petition be furnished to Ms. P. Das to enable her to obtain instructions. Stop. It is further provided herein that till the next returnable date, the respondent authorities shall not take any coercive steps against the petitioner. What about the representation? Will we have one observation also?
It will not be a bar for.
Further, there is no, the respondents are not barred from considering and disposing of the representation submitted by the petitioner.
Having 52.
Yes, Mr. Gogoi.
She has already heard the.
Yes, Mr. Chaudhary had submitted, made some submission in the morning and sum and substance was that writ petition is pending. Now they are by virtue of that, by that letter, the secretary has said that instruction to all the principals, that those who are on contract basis, they should be removed. So that's why they've come in that IA.
Otherwise, Lordship, that particular issue is settled by this our High Court, Lordship. In so many cases, the claims, the payer of the petitioner was rejected by the same set of categories petitioners came before this honorable court, Lordship. Even full bench also upheld the division bench judgment.
Now again, Supreme Court.
When Supreme Court and recent one judgment, they have bring it to the Supreme Court, Lordship. That issue is pending before the Supreme Court.
It is to be listed on a particular date, I think. What was that date? This is what? WPC, give me the IA.
It's given as 21 for your lordship, but the matter could not be taken up that day, so it was deferred. As per the order, page 17.
It is going to be taken up on 19/5.
Subsequently, it was, yeah.
19/5. So we posted after 19/5. Otherwise, you will take out that order saying that this is a covered case. The matter ends.
Otherwise also, Lordship, recently on 16th, probably Lordship, on 16/4/2026, Honorable Supreme Court has again, Lordship, after discussing Jaggut, that judgment which was placed by the petitioner. The judgment was indicated by the petitioner, Jaggut Dharam Singh, all are discussed by the Honorable Court and negated the claim of the petitioner. On the basis of the constitutional bench judgment, the Honorable Supreme Court says that they are not entitled for any regulation.
What is that judgment? In which case?
On Madan Singh and others versus State of Haryana.
Recently.
Recently on 16/4/2026, this month, Lordship.
Okay.
After discussing all the judgment which was passed by the Lordship, that judgment was
16/4.
16/4, Lordship. 16/4. And otherwise also, Lordship, that particular notification, Lordship, that particular notification, issuance of the particular notification, the basis of that, Lordship, there is a statutory prescription is there, Lordship. There is a 2005 Act is there, 2010 rules is there, Lordship. There is no provision for engagement of the contractual employees. It is the internal arrangement of the college authority. They are not the employer. They are not the employer. We have no liabilities to them, Lordship. We have not paid to them also. Not only this set of petitioners, other contextual employee also lost.
So,
It is up to the college also.
so anyway, Mr.
Lost.
Gogoi, since writ petition is already pending, we have to take a call this way or that way.
This is there also.
So we have it after 19th of May.
Lost.
On that day, you may produce your other judgment also if you want to.
And also that judgment which was relied in paragraph 15 lawsuit in Akkadas Ali's case lawsuit. That was totally a defined footing lawsuit. It's a case lawsuit whether no confusion motion was raised against the lawsuit. A GB president, cooperative society president lawsuit, and he was removed from the president of the cooperative society. Against that, he filed a writ petition, and writ petition, the honorable court said the status quo order should be maintained. In the meantime, as assistant registrar passed an order lawsuit, holding that lawsuit, he should continue with it. On that particular background lawsuit, honorable court passed the order lawsuit. It is totally a defined footing lawsuit.
Okay, please write. Per contra, Mr. K. Gogoi, learned. You are appearing as standing counsel,
Higher Education Department.
standing counsel, higher education
Yes.
department. Submits that the issue has already been settled by this court. By holding that the contract appointees do not have any right to be considered for absorption. So likewise, you have the reference of 16(4).
Yes, lawsuit. It's a Madan Singh and others versus State of Haryana and others lawsuit.
Likewise, the apex court in
Madan Singh and others lawsuit
Madan Singh and others
versus State of Haryana and others lawsuit.
versus state of Haryana and others
Civil appeal long lawsuit 1996 of 2024 lawsuit.
in civil appeal 1996 of
Of-
2024,
Lawsuit. Decided on lawsuit 16-4 lawsuit.
decided on 16/4/2026,
Lawsuit.
has held that contract appointees
Lawsuit.
cannot insist on being regularized.
On the basis of the constitutional bench judgment as well as 3 others bench judgment lawsuit, the official liquidators case lawsuit.
To stop, the learned standing counsel further submits that the case of Akkadas Ali Supra, relied upon by the learned senior counsel, is distinguishable in view of the fact that in spite of a specific direction passed by the court, the
Assistant Registrar of Property Societies.
Assistant Registrar of Cooperative Societies
Passed an order also allowing the respondent to continue the ceremony also.
issued an order allowing the respondent concerned as chairman of what?
Continue the ceremony of the cooperative society.
Chairman of the cooperative society concerned.
Yes.
Top. It is however seen that the SLPC number 7368 of 2025 bracket Nitra Moni Barwa and others versus State of Assam and others. Those brackets pending before the apex court is due to be listed on 19/5/2026. And since the subject matter of the SLP is also said to be similar to the issue at hand, This court is of the view that the matter should be deferred. Till the said case is taken up for hearing by the apex court. In view of above, list the matter again after 1965. Any convenient date after 1905? Wednesday. On 10/6/2026.
Obligations. Obligations.
Lordship, the protection maybe.
Ah. It is also provided herein that till the next date, respondent authorities shall not take any coercive steps against the petition. Or till the next returnable date, till the next date, we'll write that again, okay? Till the next date, status quo as regards the service condition of the petitioner shall be maintained.
Obligations.
The earlier order, you've got it, no? Continue with that.
Permissions 14, 15, 16 and 17.
Made legal lordship.
Hmm.
But in this batch of writ petitions, my lord,
Hmm.
the petitioners before lordship are appointed pursuant to 3 selection processes, my lord, which has been examined by the honorable court.
3 selection process.
My lord, in petition, my lord, item number 14,
Hmm.
select list dated 18/8/1995.
Hmm.
Next, my lord. Number 15, my lord, selection list dated 22/6/1992. Then, my lord, 16, 22/6/1992. And,
See, parties are ready for hearing.
my lord, ready.
You're ready?
Fine.
You are there?
Yes,
You're also ready?
my lord. In 2 cases, only we have filed our affidavit, my other cases we have not.
That will
filed.
cover,
That will be covered.
they will stand.
Will be covered. Okay, what is the issue involved in these cases?
Despite their selection, my lord, on regular basis, initially they were appointed, my lord, pursuant to the selection process. They worked, they were paid salary up to, my lord, 31st January 1997.
Hmm. Hmm. Yes,
Thereafter, my lord, salaries were stopped.
yes, then.
My lord, in the meantime, my lord, various litigations were filed by the petitioner as well as some other co-petition, similarly situated persons, my lord. In 2007, government decided to, my lord, decided that these persons were, my lord, appointed behoves the rules.
Hmm.
That orders were challenged by some of the similarly situated persons. Those petitions, 3 petitions were filed. Those petitions were disposed of by the honorable court, my lord, by a judgment dated, my lord, 16/6/2016. Whereby, my lord, it was held that those petitioners were regularly appointed pursuant to selection process, and the authorities were directed to pay them the salaries with effect from 1 February 1997, if they were working. That was the only condition, my lord, imposed in this, into that judgment, my lord. That judgment was challenged before the division bench. Subsequently, my lord, department withdrew this writ appeal, which a liberty to file a review petition. Review petition was filed, that was dismissed. Now the judgment dated, my lord, 16/6/2016, that has attained finality. In the meantime, what happened, my lord? The respondent authority absorbed all the petitioners, my lord, as tutors.
This is that case, adjustment of tutors.
My lord,
This is that case.
yes, my lord. They were adjusted as
Initially
tutors.
appointed as due process,
My lord,
salary paid up to some period of time,
my lord,
salary stopped, various litigations here and there,
my lord.
Ultimately, you said that one of the case which has attained finality, what is that?
That is, my lord, judgment dated 16/6/2016.
What does it say?
It says that, my lord, the petitioners were regularly selected
Oh,
and they were, my lord, entitled to, my lord,
Pay.
the pay,
if they are working.
my lord.
Now, while that was the order, they have come up with another formula of adjusting you as tutor.
My lord.
So that's what you have challenged now.
Yes, my lord.
Then what is the relief sought for?
I am claiming that we should be paid the salary, my lord, with effect from 1/2/1997 as we are working,
As in the scale pay.
my lord, in the scale pay, and the benefit of past services should be given to the petitioners.
Otherwise, you are tutor now.
We are tutors now.
Since when?
Since, my lord, 2020.
2020.
In the year 2021, they have passed the impugn order, my lord, 30th January 2021, and it was given effect from, my lord, 1/11/2020.
Retrospective effect.
1/11/2020, they have given the effect.
Retrospective effect.
2 months prior to the passing the impugn order, my lord.
Okay.
Not retrospective. In fact, my lord.
Not retrospective.
Because, my lord, they are entitled to salary, my lord, with effect from 1/2/1997.
No, that is a different thing. What I'm asking is that where is that appointment?
My lord,
Adjustment.
adjustment order.
124.
124, my lord.
124.
My lord.
Accommodated as tutor.
My lord.
Effective date?
Effective date is, my lord, 1/11/2020.
Where do you find that?
Prospective, Rasul highlighted person, my lord, with prospective effect from 1/11/2020. 6th line, my lord. From top, my lord.
When is the order issued?
It was issued on 30th January 2021.
21.
My lord.
So prospective effect 2020. Is it not something wrong? Something's wrong, yeah?
My lord, if it is prospective, my lord, it should have been with effect from 30th January 2021. If it was prospective, but they have given, my lord, benefit of 2 months more.
So instead of prospective, it should have been written as retrospective.
My lord.
Because your appointment is in January. You're getting from benefit from the November of the earlier year.
Earlier, yeah, my lord.
So what is your submission? How you should be given
My
from salary from what 1/2/1997?
My lord, our rights, my lord, flows from the judgment of this honorable court.
Let us come to that judgment. Where is it?
My lord, thus will find the judgment at page 89, my lord.
89. (16/6/16).
My lord. Tax loss will find at page 95. Paragraph 2 is the facts, my lord.
But this is only basically regarding salary.
Yes, my lord.
It does not talk about your condition of service.
Yes, my lord, it was held that they were regularly appointed,
Oh.
same select list.
Initially, you were given scale pay.
Yes, my lord.
Okay. Can you show me one order by which you have given the scale pay?
My lord, initial
Your
appointment,
initial appointment was when? Which year?
page 30, my lord, page 30.
Which year?
It is page 30, that is of 15/11/1995, my lord.
So that time the manual typewriter was used,
My lord,
not even computer.
my lord.
Manual, or this is cyclo style.
Cyclo style, my lord.
Mhm.
15/11/1995. They were paid regularly, my lord, regular scale of pay up to 31st January 1997.
Okay, this is 95.
95,
15 November 95.
my lord.
Why was it stopped all of a sudden?
My
Reason?
lord, what happened, my lord, perhaps, my lord, all over Assam, my lord, during that period, some excess appointments were made.
Excess appointment.
Some excess appointments were made. Therefore, my lord, all the select lists were seized by the competent authority. And my lord, the salaries were stopped. Even in Nalbari district, my lord, all the my lord appointments were cancelled. In fact, my lord, but in Karimganj district, my lord, appointments were not cancelled. They were allowed to work. They were even paid up to my lord 31st January 1997. But my lord, later on, my lord, it was stopped. Subsequently, my lord, the select list was compared by the district authority. So you'll find at page 53.
Any finding on that list, select list?
Yes, my lord. This honorable court has specific finding, my lord.
In which case?
My lord.
In which case?
Uh,
Page 89, that case.
yes, my lord.
Let us see, where is it?
Page 101, my lord.
101 paragraph?
Paragraph 12, my lord.
12. Okay, before coming to that, where is the facts narrated? In which paragraph? I think you should read from paragraph 2,
My lord.
page
Paragraph
95.
Paragraph 2 is the facts, my lord.
Yes, let's see what is the
The
facts.
case laid out by the petitioners is that they were appointed as assistant teachers in various lower primary schools in district of Karimganj by appointment orders varying between the year 1995 and 1996. Pursuant to the advertisement and selection made by the subdivisional level advisory board for elementary education, Karimganj, the petitioners contended that they were appointed pursuant to select list dated 22/6/1992 following the advertisement of 1991, as well as the pursuant to select list dated 18/8/1995 pursuant to advertisement dated 1995. The particulars as to who amongst the petitioners were appointed pursuant to the advertisement dated 1991 and 1995 advertisement have been indicated in the writ petitions. The said appointments were made against posts created by the government and upon retirement of vacancies. They were also granted scale of pay of rupees 1185 to 2295 together with allowances admissible under the rules. The payment of salary was made from the initial date of appointment till January 1997, and thereafter it was altogether stopped.
Okay.
This is the background, my lord. On this background, my lord, from paragraph 12, page 101,
Yes.
I have heard the learned counsel for the parties and have also considered the materials on record. The fact that the petitioners were appointed pursuant to select list dated 22/6/1992 and or the select list dated 18/8/1995 is a fait accompli. In that the consolidated statement prepared by the state authorities vindicates that the stand of the petitioners. The fact that the petitioners were granted salary in regular scale of pay from respective dates of their appointment until January 1997 is also not disputed. The objection now raised is that the petitioners were appointed against non-existent and non-sanctioned posts and they were not entitled to arrears salary. This is not the stand taken by the state respondents when the petitioners had first approached the Honorable Court in the year 2003. In fact,
Just stop there.
my lord,
Who approached in 2003?
those petitioners, my lord, they approached this Honorable Court, my lord, in 2003. This Honorable Court remanded back the matter to the authority, my lord,
Okay.
to my lord, pass an order by adjusting them against non-sanctioned post. My lord, sanctioned post, I'm sorry, my lord, non-planned post,
In 2003.
2003.
There was a response from the affidavit was filed.
In that case also, they have filed affidavit, my lord. Pursuant to that direction, my lord, an order was passed, which was put to challenge in this set of writ petitions, my lord.
Objection raised is that they are appointed against non-existent and non-sanctioned post. Then court says that this is not the stand taken by the state respondents when the petition had first approached
My lord.
in 2003.
In
Okay,
the
then,
second round of litigation, my lord, there is raised this objection, my lord. In the
Okay,
first
then-
round, my lord.
in fact,
In fact, although the petitioners have continued to serve in respective schools on and from the year 1995 to 1996, no step had been initiated by the state respondents interfering or questioning the appointment orders so issued, nor any such steps were taken when the matter was sent back to the government for examining the case of the petitioners pursuant to the order dated 18/7/2003 passed by this court in the earlier round of litigation. The submission of Mr. Mozumdar that appointments have been made contrary to the statutory procedure and or the prescribed procedure, in that the same was not preceded by any advertisement or participation of the petitioners in any selection process, the same do not find support from the materials on record. To reiterate, the consolidated statement prepared by the respondent authorities discloses sufficient particulars meeting the objection raised by Mr. Mozumdar. In the said consolidated statement, there is mention of the order when the advertisement had been issued, allotment of interview numbers, also supports that the petitioners had participated in the interview process. Reliance based in the case of Mamata Mohanty Supra and Nazira Begum Laskar Supra do not come to the aid of the respondents inasmuch as the present proceeding is not a case where appointment had been made by making a clear departure from the prescribed procedure or at the behest of some unseen hands. Had it been so, the state respondents would have certainly taken action against the petitioners or would have at least issued so-called notice questioning their appointment as assistant teachers. On record, no such steps have been taken by the state respondents until this date. The case laid out by the petitioners against the unreasonable and arbitrary action on the part of the state respondents gains force in view of the communication dated 16/5/2015, which had been obtained by the petitioners through the Right to Information Act. The clarification made by the Deputy Inspector of Schools Karimganj in response to the government letter dated 7/8/2015 abundantly goes in favor of the petitioners, at least to the extent that the selection made by the subdivisional level advisory board for elementary education Karimganj, also which all original records had been submitted to the government way back in the year 1998. It was so done because of the government WT message dated 23/4/1998. This clarification made by the Deputy Commissioner of Schools Karimganj gains significance in that it was well within the knowledge of the state respondents way back in the year 1998 of the selection made by the advisory board and also the appointments offered to the petitioners herein. As is revealed from the said communication dated 16/9/2015, there is no denying the fact that all the petitioners have been continuously rendering the services since their initial date of appointment. The exception, however, is in respect of the petitioner number 2 in Madhumita Goswami in WPC number so and so. She was not found in the select list mail. As held by the division bench of this court in the case of State of Manipur Supra, that when services had been rendered and received by the state government without questioning the person rendering such services, that his appointment is illegal, it would not be just and fair for the state not to pay the wages or salary to such person for the period during which service was rendered by him. Denial of salary would only amount to victimizing the person to forced labor by the employer concerned. It is also no more res integra that claim for salary for the period during which service is rendered is not based on tort but on principle of quantum merit. It is not implicit that a person serves the employer ex gratia or that his salary is in the nature of bounty. The legal position being clear as much as regards the claim for the salary, it is not open for the state respondents to deny and deprive the petitioners from their entitlement as regards salary. To reiterate, the petitioners are continuously serving in their respective category, and the state respondents have also allowed them to continue as such. When service is extracted, it is also corresponding obligation and duty on the state respondents to provide due salary to the persons concerned. From the discussion above, the inevitable conclusion is that the petitioners have been able to make out a case for seeking appropriate relief from this court. To that extent, have also made out a case that state respondents under any circumstance cannot deny payment of salary to the petitioners for the period during which they have rendered uninterrupted service. In view thereof, this writ petition stands to be allowed with direction to the state respondents to make payment of arrears salary to the petitioners with effect from February 1997, as well as to continue making payment of current salary. Insofar as the payment of arrears salary is concerned, the same shall be paid and disbursed within a period of 6 months from the date from today, and while doing so, the state respondents are also allowed to carry out a verification process to ascertain the period from which the petitioners have been discharging services as teachers uninterruptedly until this date. So, my lord, these petitioners were also appointed from the same select list of 1992 and 1995. This select list has been examined by the Honorable Court, and finding them to be regularly appointed, the state respondents were directed to pay the regular scale of pay to the petitioners with effect from the date when it was stopped. This judgment was challenged before the division bench. Division bench, they withdrew the writ appeal. Subsequently, my lord, they preferred a review petition. The review petition was, you will find at page 105. And the operative part lawsuit will find at page 122, my lord.
Review was preferred against the
Against the judgment dated 16/6/2016, my lord.
single bench.
Single bench. My lord, the original author of the judgment is Honorable Mr. Justice Manjit Bhuya, my lord. As he retired, my lord, subsequently, my lord, it was taken
Review
up
was
by-
taken up by somebody else.
My lord. That review petition was dismissed, my lord, by judgment and order dated 28/4/2023, my lord. That operative part lawsuit find at page 122. Therefore, in view of the discussion above, this review petition fails on 2 counts, maintainability as well as on merit. Accordingly, the review petition stands dismissed. The parties are left to bear their own cost. So, my lord, this judgment of 16/6/2016 has attained finality, as that has not been reviewed, nor it was altered by the Honorable Division Bench. Now, instead of paying them the regular scale of pay, along with the my lord, benefit of their past services, by the impugned orders at page 24 onwards, page 124 onwards, the respondents have, my lord, accommodated the petitioners as tutors against a fixed pay at the rate of 10,800.
So in the other writ petitions also same thing,
Same thing,
similar order.
similar orders.
What do they say? Other side.
My lord, they have filed the affidavit, my lord. They have in their affidavit, they have not controverted our averments made in the writ petition. In fact, my lord, that can be presumed to have been admitted by them, my lord, by applying Nasim Banu. They have come up with a plea that during pendency of the earlier litigation, a screening committee was constituted by the government. That screening committee examined the cases of the petitioners. They were found to be, my lord, illegal appointments.
illegal appointees by the screening committee. And therefore, my lord, they were not given the regular scale of pay. And my lord, by a policy decision, the government has decided to accommodate those persons, my lord, as tutors. That is the only stand taken by the responding authorities. Now, my lord, in view of the findings of this honorable court, while examining the earlier, examining the select list, the screening committee cannot say that the petitioners are, my lord, appointed illegally. There is a specific findings of this honorable court that these petitioners are legally appointed pursuant to selection process. The observation made by the screening committee cannot, my lord, override the findings of this honorable court. Therefore, my lord, this law, your lordships may direct the respondents, my lord, to give benefits of the past services to the petitioners. Because, my lord, if they are not given the benefit of the past services, apart from losing the salaries of the past services, they will lose all the service benefits, my lord. They will not even get the pension also, my lord, though they are working since 1995. Recently, my lord, while considering the cases of OBB teachers in Nalbari district, my lord, the according bench of this honorable court, my lord, has held that, my lord, those appointments were cancelled illegally, and it was directed, my lord, to pay the to reinstate those petitioners and pay them the, my lord, salaries for the period they have rendered services by giving all the consequential service benefits.
Come to your prayer. Let's see.
My lord.
19 or it starts from 18.
Is 18 onwards, my lord.
Hmm.
Prayer 3, my lord, I'm not pressing, my lord. Prayer 3. Because, my lord, that was, my lord, product of copy paste, my lord, that is not there in this set of cases, my lord.
Sorry.
That undertaking is not there in this case, my lord. So, my lord, prayer 3, that is, I am not pressing.
Old pension.
My lord, that has been, my lord.
Prayer fees regarding old pension.
My lord, my lord. My lord, if they are given the benefit of the past services, my lord, they will automatically be covered by the old pension rules, my lord. Because they were appointed in the year 1995. New pension schemes, my lord, came in the year 2005.
So ultimately, your case boils down to that decision already held, arrived at by this court, isn't
My
it?
lord, my lord,
This has attained a finality.
my lord.
Was there any break in your service
No, there is no break.
since 95?
95, since 95, these petitioners are, my lord, continuously working,
I'm just working.
my lord, without any salary.
So
My lord,
you are working with salary up till 31st of January 1997.
97 also.
So thereafter, there was no salary.
There are no salary.
Salary came only after you were adjusted as tutor.
Tutors.
Salary was started from November 2020 only.
My lord, in the case of, my lord, state of Uttar Pradesh and others versus on Arvind Kumar Srivastava, the Honorable Apex Court held that, my lord, similarly situated persons, even if approaches this Honorable Court, my lord, on a belated stage, they are entitled to the same reliefs, my lord.
The thing is, you see, you have not received salary from the month of February 1997 up till October 2020.
Regular scale of pay.
Salary you have received, not regular scale.
No salary you have received, my lord, till my lord adjustment as tutors, my lord. See,
Prior to adjustment as tutor, you have not received.
up to my lord 31st January 1997, we received.
But
Thereafter, my lord, no
that's
salary,
what I'm saying.
my lord.
So for 23 years, how did you survive without salary?
Perhaps, my lord, they were doing some other works and apart from doing the duties, my lord, like tuitions and all, my lord. The teachers, my lord.
And have you approached the respondents?
Number of occasions they approached the Honorable Court.
No, in
my lord,
this
the
rate petition.
district authority, my lord, they have, my lord, they sent proposals on number of occasions, my lord.
What is this?
These are the decisions, my lord,
Which you will be relying upon.
my lord. Regarding, my lord, same relief, my lord.
Okay, let me just sum up what you are saying. You are saying that 1995, you are appointed after due process,
My lord.
continued receiving the scale pay only up till 31st January 97.
My lord.
Thereafter, salary stopped.
My lord.
Then a few years down the line, after several litigation, this is your case, is it? This page 89,
My lord.
you are the petitioner there.
My lord.
It's a common order or only on a single writ petition?
Common order, my lord. Three
Common.
petitions were taken up together, my lord.
3 writ petitions.
My lord.
So these 3 writ petitioners are now before this court today also.
No,
They're different.
they are different, my lord. They are from the same select list.
Okay, they're from the same select list.
My lord. That is why, my lord, I am relying on the same relief judgment, my lord.
Okay, and what about them? They're not come before this court for
My
the
lord,
relief.
they have not come before this honorable court, my lord. They are filing this their writ petition, my lord, because my lord, contempt petition was pending. Contempt petition is,
No, this petition is in page 89.
my lord.
What about them? What is their situation?
They are also, my lord, adjusted as tutors.
Okay, they have not come before the court.
They, my lord, the contempt petition was pending before this honorable court because, my lord, there is a plea was raised by the petitioners that the adjustment orders itself is, my lord, contempt. Because this honorable court directed the authority, my lord, to pay them the regular scale of pay. They cannot, my lord, adjust the petitioners, my lord, as tutors.
This
But
order-
subsequently, my lord, in a
See, this order was rendered when? 2016.
16.
So
In review
between
petition,
2016 and 2021, what happened?
my lord, review petition was disposed of in the year 2023, my lord. Review petition,
Review petition against this judgment.
my lord.
Where is that order?
Review petition judgment is there, my lord. That judgment also will find at page 105, my lord.
105.
My lord.
105.
That was dismissed on, my lord, 28/4/2023.
Twenty-eight 4/2023.
My lord.
Dismissed.
My lord.
What was the ground for review?
The same ground was taken, my lord. Same ground was taken that the persons were found in the category of illegal teachers by the screening committee. So they are not entitled to the regular scale of pay.
These review petitioners and the original petitioners are not the petitioners today, isn't it?
They are not the petitioners.
They are different, but
They are
similarly situated.
They are from the same select list, my lord.
Same select list.
My lord.
Okay. Then review petition, how it was dismissed? Both on maintainability and on merits.
My lord. Because, my lord, review was preferred by only two respondents, my lord. There were respondents in their original writ petition. That is the technical ground. The other ground, my lord, on merit also, my lord, there is not, my lord, this honorable court was. pleased
After
to-
review, there's no further appeal,
There is no appeal. After
no
review,
appeal.
no appeal.
Review was disposed of in
On
the year 2023.
23, my lord.
And in the meantime, that adjustment order was there.
In the meantime, my lord, the adjustment order was there. And this honorable, my lord, contempt petition was pending. Recently, my lord, contempt petition has been closed,
Hmm.
granting liberty to those petitioners, my lord, to challenge the, my lord, adjustment orders. Because
Okay, that's
in-
how the adjustment orders have come now. Do you have the order of that contempt?
Contempt order, I will, my lord, I can.
You don't have. How many contempt petitions?
Three contempts were filed, my lord. Three petitions were taken up together in the earlier round of litigation, my lord.
Wow.
Three contempts were filed by all those petitioners, my lord.
And review petition was filed before that? Or after
During-
contempt?
During pendency of the contempt petition, review.
They filed review.
They filed review.
Review got dismissed.
Review got dismissed.
Contempt
Subsequent-
also got dismissed.
In the month of February,
Contempt got closed
got closed.
later on.
My lord, in the year 2026, my lord, February 2026,
Contempt got closed.
my lord. Granting liberty to, my lord, approach the honorable court challenging that order, my lord.
Let us have that order. Do you have the case number? We'll get it printed from you. Contempt case number.
Let's.
The order of accommodation, they have refused to, my lord, claim the past benefit. Order of accommodation, it is reflect, my lord. They refuse to claim the past benefit. And they
Are they in a position to refuse?
they were accommodated as tutor, as per the cabinet decision.
Probably you must have said that if you don't take this, we'll not give you anything. So they had to take it.
I'll give the, my lord,
All right, yes. And what is this authority? This is to counter what Mr. Standing Counsel will
this is, my lord,
say, that you are fence sitter,
yes, ma'am.
to counter that fence
My lord.
sitting.
My
Okay.
lord.
Which one do you want to cite first? K.C. Sharma or Ajant Boro?
K.C. Sharma, paragraph 6, my lord. Paragraph 6, small judgment, my lord.
Small judgment. Give me the small facts then.
My lord.
What was the issue
The
there?
appeal, I am reading from paragraph 3, my lord.
Yes.
The appeal is directed against the judgment of the principal bench of Central Administrative Tribunal dated 25/7/1994 in way number so and so. The appellants were employed as guards in Northern Railway and they retired as guards during the period between 1980 to 1988. They felt aggrieved by the notification dated 5/12/1988, whereby Rule 2544 of the Indian Railways Establishment Code was amended and the purpose of calculation of the average emoluments, the maximum limit in respect of the running allowances were reduced to 75%, reduced from 75% to 45% in respect of the period 1/1/1973 to 31/3/1979 and to 55% from the period 1/4/1979 onwards. The validity of the retrospective amendments introduced by the impugned notification that so and so had been considered by full bench of this tribunal in its judgment in Sierra Ranga Thamaiya versus Chairman Railway Boards and connected matters, and the said notification insofar as they gave retrospective effect to the amendments were held to be invalid as being violative of Article 14 and 16 of the Constitution. Since the appellants were adversely affected by the impugned amendments, they sought the benefit of the said decision of the full bench of the tribunal by filing representations before the railway administration. Since they failed to obtain redress, they filed the application OA number so and so seeking relief before the tribunal in April 1994. The said application of the appellants were dismissed by the tribunal by the impugned judgment on the view that the applicants were barred by limitation. The tribunal refused to condone the delay in filing the said applications. The correctness of the decision of the full bench of the tribunal has been affirmed by this court in Chairman Railway Board versus C.R. Rangathamaiya and connected matters decided today. Having regard the facts and circumstances of the case, we are of the view that this was a fit case in which the tribunal should have condoned the delay in filing the application and the appellants should have been given the relief in the same terms as was granted by the full bench of the tribunal. The appeal is therefore allowed. The impugned judgment of the tribunal is set aside and delay in filing so and so is abandoned. That is, the same relief has been granted even if they were not party in the first round of litigation, madam. In Arvind Kumar Srivastava, madam.
See, this is regarding that retrospective amendment
Madam.
of that emoluments being reduced from an anterior date.
My lord, because I am
So-
citing these decisions, my lord, because
So just listen. So the full bench of the tribunal said that this cannot be done. It was held to be invalid for being violative of Articles 14 and 16. That full bench tribunal decision was decided by the Supreme Court again. Supreme Court upheld.
upheld,
So another batch of person had also tried that same relief.
my lord.
It
They
was
were denied.
rejected. Delay was not condoned.
My lord.
Supreme Court said that they should have condoned.
My lord.
Since we have already upheld the decision of the full bench, so they should also be given the
Given the
benefit.
same relief. my lord.
You have brought this decision into the picture to show that although you were not the litigant in that case,
Yes, my lord. Yes.
you should also be given similar
my lord.
benefits. Okay. Then what else?
My lord, paragraph 22 of my lord Arvind Kumar Srivastava, my lord.
Where is that? Have you given me that?
State of Uttar Pradesh and others versus.
Oh, yes, yes.
My lord. Paragraph 22, my lord.
Same treatment should be given, otherwise Article 14.
My lord.
This is the thing.
My lord. And this has been followed, both these judgments were followed by the Honorable Division Bench of this Honorable Court, my lord, in my lord, Union of India and others versus Anand Borough.
Then what is this concept of fence sitters then? Concept of fence sitters. Say,
Let's-
some people will come to the court and get relief. Others will not do anything, they'll just watch. They come at their own sweet time. So in such case, court also says that you are a fence sitter, you should not get the benefit.
My lord.
How do you distinguish?
In that case, my lord, they can be distinguished. Perhaps, my lord, not true, my lord, it will go against me, my lord. They can be distinguished by following another judgment wherein the Honorable Apex Court held that, my lord, from the date of filing, prior to filing of 3 years, benefit was given. The other benefit was not given.
Or relief was given, but
Relief
only,
was given,
but only from a certain period of
for
time.
a from the date of filing,
Hmm.
3 years prior to filing, 3 years, my lord,
3 years.
my lord. As they are fence sitters, my lord.
So we sum up as and then. Okay, please read 22.1.
My lord. The normal rule is that when a particular set of employee is given relief by the court, all other identically situated persons need to be treated alike by extending that benefit. Not doing so would amount to discrimination and would be violative of Article 14 of the Constitution of India. This principle needs to be applied in service matters more emphatically as the service jurisprudence evolved by this court from time to time postulates that all similarly situated persons should be treated similarly. Therefore, the normal rule would be that merely because other similarly situated persons did not approach the court earlier, they are not to be treated differently.
Yes, now the catch is at 22.2.
Madam. However, this principle is subject to well-recognized exception in the form of lapses and delays as well as acquiescence. Those persons who did not challenge the wrongful action in their cases and the acquiescence also into the same woke up after long delay only because of the reason that their counterparts who had approached the court earlier in time succeeded in their efforts, then such employees cannot claim that the benefit of the judgment rendered in the case of similarly situated persons be extended to them. They would be treated as fence sitters and lapses and delays and or the acquiescence would be a valid ground to dismiss their claim. However, this exception may not apply in those cases where the judgment pronounced by the court was judgment in rem with intention to give benefit to all similarly situated persons, whether they approach the court or not. With such a pronouncement, the obligation is cast upon the authorities to itself extend the benefit thereof to all the similarly situated persons. Such a situation can occur when the subject matter of the decision touches upon the policy matters like scheme for regularization and the like. On the other hand, if the judgment of the court was in personam, holding that benefit of the said judgment shall accrue to the parties before the court, and such an intention is stated expressly in the judgment, it cannot impliedly found out that tenor and language of the judgment, those who want to get the benefit of the said judgment extended to them shall have to satisfy that their petition does not suffer from either laches and delays or acquiescence.
Hmm.
So in this case, the earlier judgment was a judgment in rem. There is no mention that this judgment will be applicable would only in respect to the petitioners. Because the Honorable Apex Court says that if it is made clear that judgment will be applicable only in respect of petitioners, if it is judgment in persona, then only, my lord, delay should be considered. Otherwise, if it is a judgment in rem, that should be applied to all the persons, my lord. Here, my lord, the petitioners are also, my lord, selected from the same selection process. So, my lord, it should have been applied to the cases of the petitioners also. And while, my lord, applying the same thing, my lord, otherwise, my lord, perhaps, my lord, they would not have, my lord, adjusted the petitioners as, my lord, tutors also. They have adjusted the petitioners as well as the petitioners in those petitions as, my lord, tutors by order passed on the same date.
Mr. Saikia, I've understood. Go to the next decision.
This decision is the decision of
Ajan Boro.
Anand Boro, my lord. Here, my lord, paragraph 15 and 16.
16, 15.
15 and 16, my lord.
Again, let us see what is the facts here.
My lord. The instant writ petition is filed against the order dated so and so passed by the learned Central Administrative Tribunal, Gauhati bench, in original application number so and so, whereby the learned tribunal dispose of the original application as mentioned above by a common judgment, directing the respondents to constitute a responsible committee with senior officials to scrutinize the available records of the applicants for regularization as per the direction in number so and so. If requested by giving a personal hearing to each individual and consider the case individually, pass appropriate orders and communicate them the same to the applicants within a reasonable period, in any case within 4 months from the date of receipt of the order. Before determining the legal issues raised by the parties, the factual background of the case is, in nutshell, is narrated herein below. The respondents herein are the applicants in OA number so and so. There are 41 applicants. They were all ex-casual laborers working under the petitioners herein. The petitioners are represented by the Railway Government of India, more particularly represented by the General Manager NF Railway Maligaon, and other petitioners are the officers of the NF Railway. The cause of action of such initiation of case started in the year 1996, when a batch of similarly situated ex-laborer labor employees serving under the railway approached the tribunal by way of filing application being OA number so and so. The tribunal the tribunal disposed of the aforesaid OA, directing the railways to consider their cases within a stipulated time. The applicants on the same OA were granted benefit of temporary status. The case of the respondents herein is that though they are similarly situated to the applicants in OA number so and so, their cases were not considered in the screening held by the railways, and as such they were deprived of an opportunity for consideration of their cases for appointment on regular basis under the railways, thereby discriminating in the matter of regular absorption, which culminates in preferring the OA mentioned hearing above. It may be pertinent to mention herein that the respondents herein had preferred OA number so and so before the learned tribunal, wherein and whereof the tribunal directed the applicants to submit their representations, giving the details of their services as far as possible, and the respondents railways were directed to dispose of the same. While taking up the cases of the respondents by the railway directed them to produce documentary evidence relating to identity cards. However, their cases could not be considered on the ground that genuineness of identity cards could not be established, and on that ground, the railway rejected the representations by the impugned orders that is so and so. Earlier to the above mentioned OA, the respondents herein had preferred OA number so and so before the learned tribunal. The learned tribunal had disposed of the aforementioned OAs, directing the applicants therein to make representations setting out their respective claims. The said applications were rejected by the railway on 18/3/20.
Okay, Mr. Saike. I think more or less, I think it's clear.
Same.
Now, the learned single judge has relied upon this 1997 6 SCC also, that K.C. Sharma's case.
Yes, my lord.
which you had cited earlier?
Both the cases have been relied upon, my lord.
Both cases, is
Both
it?
the cases have been
Both case means-
relied by the division bench, my lord.
Arvind Kumar also?
My lord.
No, Arvind Kumar is 2015. This judgment is rendered in 2009. 8,
Oh,
2009.
sorry, my lord. Arvind Kumar, my lord.
Arvind Kumar came later on.
Dharampal was, my lord, relied upon. Dharampal. I have got a Dharampal judgment also. my lord.
Names of the applicants are available in the supplementary live casual labor list and were verified by officers of railway and found correct. Dharampal.
That was relied on, my lord, by the annual division bench.
What is the relevant one? Dharampal?
Paragraph 3, my lord. 3 and 5, my lord.
What about the other cases? They are same.
Same, my lord.
They are all same.
They are all same. Only, my lord, in respect of 1999 select list, my lord, in the earlier judgment, my lord, it was not mentioned regarding the 1999 judgment, select list, my lord. But in the consolidated statement, which has been, my lord, relied on by this honorable court in the earlier round of litigation, my lord. In the consolidated statement, the select list of 1999 also takes place, and that was examined in the select list of 1999. The petitioners are there, and even in the consolidated statement also, my lord, everything has been mentioned regarding their selection. Two select lists were examined in the judgment dated 16/6/2016, that is of 92 and 95. 99 was not examined because in that batch of petitions, my lord, no persons were there from the 1999 select list. And 99 from the persons, as regards the, my lord, petitioners from the 1999 select list, my lord, they are not getting salary from the date of their initial appointment.
How many select lists are there?
3.
What are those? Just repeat that. This present case pertains to which select list?
Select list dated, my lord, 18/8/1995,
18/8/1995.
my lord. Next, my lord, Nichuranjan Dhar.
Where do we find that in this?
Select list, I have annexed, my lord. I have annexed all the select list, my lord.
Yes, that's what I'm asking you the page number, that's all.
I'm sorry, my lord.
It's page 22, I think, annexure
Page
1.
22, annexure 1 is the
Annexure
copy.
1.
I have also given the original.
This is the select list,
This is the select list of
particularly for these petitioners,
my lord,
for these petitioners only.
my lord.
And for the other cases, it's a different date.
My lord, in the item numbers 15.
Give me
item
the
number
other item 15.
is select list dated 22/6/1992.
Just a minute.
Select list also will find at
Page?
page 25.
25. 22/6/1992.
My lord.
Then what about the accommodation? The dates are same or different?
My lord,
Accommodation as tutor.
same date, my lord, same date.
Accommodation as tutor
date,
same.
Same date, my lord.
Okay. but the select list is different. Now, the select list is of 1992.
1992.
So they started working from 1992?
92, they started working from my lord 92, 93, like that, my lord. The initial appointment loss will find in respect of petition item number 15. First one of the appointment I have given, my lord, page 42,
42.
my lord. Date
This
of
is,
appointment I have mentioned in annexure 3, page
what is the date? This is also 95.
95. Date of appointment, all are 94, 95, my lord. 93 also dear, my lord. Annexure 3 is the particulars, my lord, I have given. Annexure 3, page 43, my lord. Date of appointment, salary received up to everything I have mentioned, my lord. Serial number in the select list also I have mentioned. Page 43, my lord.
Now you say serial number. Does it mean petitioner number? Serial number?
No, serial number in the select list, my lord.
Now, who are these persons?
These are the petitioners, my lord.
So what is their position?
In the position, loss will find right.
I mean, who is petition number 1, who is petition number 2, like
Petition
that?
number 1, I have given the petitioner as well as serially.
Serially, that's what I'm
My
asking you.
They are
Serially.
posted in the select list, loss will find in the right hand column, my lord.
Their position, the select list is different. It's in column number 6.
My lord.
Column number 1 is petition number.
Petitioner number.
1, 2, 3, 4. It goes
My lord.
to that. Okay. So all in all, there are 33 of them. How many of them? 33. Or there are more?
My lord.
Total, how many petitioners?
Here, my lord, 33 petitioners. my lord.
33 petitioners. Now, have you provided the similar list in the other case? Item number 14?
Here also I have given a particular, these are particular space 31, my lord.
Particulars 31.
Space 31, my lord.
Hmm. Out here, there are 15 petitioners.
My lord.
But the date of appointment seems to be same. Correct? 15/11/95.
15/11/95, my
One
lord.
of the appointment orders.
All of them were appointed on the, my lord, 15/11, 15/12, my lord.
Hmm?
One is 15/11, the others were appointed, my lord, 15/12, my lord.
Okay.
Yeah, because,
15/12.
my lord, item number 16 also from the same select list of 1992, my lord. 22/6/1992.
This is also same select list.
Same select list, my lord.
How many writ petitions in all? 3.
Here, my lord, only 2, my lord. Lina Majumdar,
No, how many writ petitions have you filed?
4 with petitions, my lord.
There are 4.
4 with petitions.
So 2 cases have a common select
Select
list
list,
of 22/6/1992.
my lord.
An appointment happened on which date?
Appointment is 37, my lord.
15/12/95.
My lord, 15/12/95.
How many petitioners are here?
Here, 2, my lord.
Only 2.
2. Lina Mazumdar, in the case of Lina Mazumdar, two Mazumdar.
You have not given the particulars separately? No.
I am giving their particulars, my lord, by writing my lord. The petitioner number one is at place one, serial number 123, my lord. And petitioner number two is serial number 152 in the select list, my lord.
Please repeat again. Serial number
Petitioner number one is 123, my lord.
and
Petitioner number two, 152.
okay. Lina Mazumdar.
Lina Mazumdar,
This is petition number one.
my lord. One is 123. Petitioner number two is 152.
Lina Kanta Datta.
My lord. Number 17, my lord. This is
17 is also there.
17 is select list dated 27/10/1999.
Twenty-seven.
27/10/99, my lord.
From where are you seeing that? Page number.
My lord, page 20, my lord. Page 20 is the select list, my lord.
How many petitioners?
Here, my lord, 6 petitioners, my lord.
And their appointment?
Their appointment loss will find at page 23, my lord.
Hmm. Twenty
2011.
1999. Any particulars given here?
I have given the particulars at page, my lord, at 25, my lord.
25. Where is your adjustment order?
Adjustment order, page 107, my lord.
This is in the by way of additional affidavit or what? 107.
107, my lord. In the writ petition, my lord. 30th January 2021, my lord.
Oh, there is no counter affidavit in this case.
In this case, no affidavit has been filed.
Okay, so it's basically this is a writ petition totaling to 110 pages.
My lord.
107 is your adjustment.
My lord.
This
Same,
is
date,
in,
same,
this
same,
is in
same.
respect of one of them only, isn't it?
My lord, I have given all the adjustment orders, my lord.
We have given all.
All.
Where have you annexed it?
107 to 112, my lord.
My compilation contains only 110. 111, 12 is not there.
Same date, my lord, same adjustment order, my lord. Same date. 30
Second file is there.
30 January 2021, my lord. Same date.
WPC 3839. How many pages are there in the writ petition? Twelve. First copy, 2 pages is missing. Anyway, second copy has the thing.
I'm sorry, my lord.
Okay. So basically that is your case.
My lord.
And they have filed counter affidavit in which case?
Item number 14 and 15.
Item number
14 and
14 and
15.
15 they have filed. affidavit.
14 and 15.
My lord.
I have also filed rejoinder in this case. my lord.
Okay. Mr. Saiki, are you done?
Fine.
Let me hear Mr. Bora. He's very impatient.
I am relying on my annexer 1
Hmm.
for affidavit, that is cabinet memorandum. my lord.
Which affidavit in which case?
My lord, item number 14, my lord.
14,
My lord. 148 page number.
page 148.
My lord. This is cabinet memorandum. As per this memorandum, they were accommodated as tutor, my lord.
So what happened to the judgment?
Regarding review, my lord.
Review also gone.
This was,
Contempt also closed.
my lord. They were accept, my lord. As tutor, my lord. Here, my
So you put a whitewash over that by giving me cabinet memorandum.
my lord. Kindly see, my lord. May I read it, my lord?
Yes.
Subject, my lord, regularization of irregular illegal appointed teacher of lower primary and upper primary school for creating supernumerary stroke personal postman. Introduction of background, my lord. A
Hmm.
large number of teachers were appointed irregularly, illegally in lower primary and upper primary school all over the state during the period of 1989 and 1991 to 2001.
Hmm.
More particularly in Dhemaji, Lakhimpur, Sibsagar, Kasar, Karimganj, Hailakandi, Bongaigaon, Nagaon, Dibrugarh, Jorhat, Golaghat, Nagaon, Morigaon districts by some field level officers and some managing committee without following the provisions laid down in the Assam Elementary Education Provincialization of Services Act 1974 as well as the rules of 1977. In terms of the Honorable Court's final order dated 2/3/2010 passed in WBC 1048/2004, the Education Department pleased to place the matter for regularization of irregular teachers before the cabinet in its meeting held on 26/2/2011 with a view to examine name of appointments, the names of appointments, status of post, working status, salary.
Just a minute. What is this case? 1048 of 2004?
Hello.
Was it referred to by Mr. Saikia? Any point?
This is Monu
1048?
Sharma.
Order date is also
2010, my lord, that is.
2010.
My lord.
Where's that order? Is it a part of these records? Mr. Saikia?
My lord, this case perhaps, my lord, relating to regularization of illegal teachers in those districts which has been mentioned. This Honorable Court directed the authority to constitute a screening committee and a screening committee to consider those cases of illegal teachers. But herein the petitioners are not my lord, covered by that screening committee because they are not illegal teachers, my lord. They are regularly selected candidates. my lord.
No, that's okay, but I just wanted to see this order. Because you are relying heavily on this cabinet memo.
My lord, my lord.
So we should know at least what is this.
I'll, please, I'll,
You produce this, okay?
my lord.
Please continue reading.
License.
While with a view to examine the name of the appointment, status of post, working status, salary, academic qualification, etc. The Director of Elementary Education Assam invited application from these irregular and illegal appointed teachers during 1991 to 2001, my lord. Throughout the state by an advertisement dated 1/20/2012 and 4/2/2012 in local newspaper. In response to the aforesaid advertisement, applicants were received from such categories of teachers. After preliminary examination of the application, so received at the directorate level, the Elementary Education Department constituted 5 screening committees headed by the Divisional Commissioner, concerned principal secretaries, and 6 scheduled areas to examine these applicants' preliminary committee report. As a detailed
after a detailed and thorough scrutiny of the reports and also after affording personal hearing to the applicants, the screening committee submitted report to the government, and after examining the government level, the following facts have been noted. As per this, my lord, this three category were created, my lord. They were, my lord, kindly see, my lord, our affidavit we have stated, my lord, that page 145. First one is the teacher who have received salary up to 2007 and onwards and having JBT, DLAD are included in list one. And second,
145.
145. In here, my lord, this in, we have 145, we have stated in para 9. my lord.
JBT means? What is it?
Junior basic training. my lord.
Okay.
Second, the teacher who have received salary up to 2007 and onwards and not having JBT, BT, DLD are included in the list two. And third one, who have neither received salary nor having prescribed training, that is JBT or DL. Well, here the petitioner are the category of second category petitioners. Well, that is we have stated in our para 11 of our affidavit.
They're not having JBT.
My lord, true.
Was it a necessity that time?
Yes, my lord.
You have stated in which paragraph?
Para 11,
Yes.
page 145, 146.
Yes.
The name of the petitioner, Onu Paul Chaudhary and 14 others in the present petition are included in list two and accommodate as tutor who have received salary up to 2007 onwards and not having JBT deal and illegal irregular category. As per the decision of the cabinet committee, we have accommodated the petitioners as tutor.
They belong to illegal or irregular category.
My lord, they were participated in the advertisement, my lord, issued by the, floated by the government, my lord, in 1 to 2012 and 4 to 2012.
Hmm.
That is why they were accommodated as tutor, my lord.
Just 1 minute, Mr. Saikia. You are relying upon those judgments, saying that we should be given similar benefit. Who has been given similar benefit?
Matlab the other persons, matlab in the cases of Sika Dasgupta and all, matlab,
Where are they?
16 judgment benefit of 2016 judgment, matlab,
Ah.
we're claiming the benefit fine.
But they are also not given.
In fact, they are also not given.
They are also not given.
They are.
But they
This
were
is
also
the order in the
not
contempt
party in the, say, petition and review petitions.
You are claiming similar benefit to those like another person who also have not been given.
Should we take up this matter as part on next Friday, my lord? Because the other petition is also being prepared by me, my lord. I'll file on Monday.
You'll file,
For those petitioners, my lord. In the batch of three cases, my lord.
you're filing what?
Yeah, I am challenging their accommodation order, my lord.
Already filed or you're going to file?
We are filing on Monday, my lord.
You're filing on Monday?
Monday. In fact, my lord, last night, we drafted the petition. It
No,
will
no.
be finalized.
What are you filing on Monday?
Monday, my lord, those petitioners who are challenging them, my lord, those petitioners in the judgment of 16/6/2016,
Ah.
they are challenging the accommodation order.
They have not challenged till now.
They have not challenged. The contempt order I have given, my lord. Because they did not challenge as the contempt petition was pending. And now, my lord, this honorable court has held that, my lord, they are required to challenge these orders also, my lord.
Okay.
My lord, the order mentioned referred in the cabinet memorandum, my lord.
So you
Have
have,
printed.
oh, it's a short order,
Short order.
but difficult to read. Is it because of the printer?
My lord, earlier judgments are, my lord, printed like this only, my lord.
Huh? No, no. The ink is very faded. Is it because of the printer? Or it is uploaded in a faded manner?
Print, I have taken here, my lord.
Can you print another copy? Legible copy?
একটু ভালো করো, মানে একটু কপি করে প্রায় portfolio তো লাগবে,
Mr. Saikia, it just occurred to me that the similarity which you are claiming, those people also have not got the relief. Only order they've given, but
my lord.
in
they got the
theory,
order,
in theory, they've got it. But actually that benefit they have not
practically they
got.
have not got the benefit.
So
Despite.
unless they get that benefit, again, you cannot say that I also wish to get that benefit. All of you are in the same boat now.
Should we take up this matters, my lord, on
So we
Thursday,
cannot complete the matter today. It cannot be completed like that.
next Thursday, my lord? Next Thursday, my lord? Because in the meantime, my lord, I will take that petition also, my lord, along with this concept with petitions, my lord. Because their stand is clear, my lord. In that petition also, perhaps, my lord, no affidavit is required to be filed, which is going to be filed by the petitioners on Monday, my lord.
Mr. Bora has taken us to the cabinet memo,
Yes, ma'am.
which relates to a writ petition disposed in 2010.
10. That order says.
Same. Oh.
কপি কৰি word file বনাই দিও, কপি কৰি word file বনাই দিলে তেতিয়া ক্লিয়াৰ আহে।
So somebody produce the clear copy next date. Oh. Will the file be available? Kim? 2004? We might as well get the file. What, this is a division bench? Order by division bench,
Division bench file,
but it's a writ petition.
writ petition.
Why it was taken up by a division bench?
Perhaps, my lord, it was referred by not a single judge, my lord, for difference of opinion
Referred.
referred.
I see. So we'll list it some other day with this records of this case.
On 7th, my lord, as part of matter, my lord.
7th is what?
Thursday, my lord, next Thursday, my lord.
11 matters. But there's no part hard, isn't it?
The 7th on lordship will take up as part of matter, my lord, because lordship has heard the matter, my lord. Entire matter has been heard.
There's one part hard on 7th. Then on 12th also there's one part hard, I think. Hmm? Hmm? 21. But we don't know the roster, huh? 21. What will happen?
Seventh, my lord, we'll try, my lord. On seventh, my lord. It will be fresh, my lord, on seventh.
No.
Next Thursday.
That's okay, but thing is that there's another part hard matter on 7th. And there are 11 matters already.
This matter, my lord, perhaps, my lord, will take much time. Only that petition is to be considered by your lordship, my lord.
It is easy to say that from your side. I will take 2 minutes,
Yes,
but court will take time to analyze and, hear the other
yes,
side,
yes, my lord.
pass the orders. Because it's not only your case, there are many other cases, that's why. What about before 7th, 5th and all that? 9 matters. Any part hard matter?
On
Oh.
fifth also, lordship may take up matter.
Mr. Bora?
Can it be on 14, my lord?
Why? 14?
If I have no problem.
You have no problem.
Fifth,
Since we have opened the brief, so
Well,
we could
no,
might as well
my-
complete it.
my lord,
The earlier the better.
my lord, on
Again, we'll forget and again we'll have to start from beginning.
on fifth, my lord.
Please write hard in part. These matters again as part hard on 5th of May 2026, along with the case record of WPC number 1048 of 1048 of 2004.
Four.
Let us see, we can do it on 5th, all right? Instead of going further and further.
oblige, my lord.
Yes.
This matter is relating to compassionate appointment.
Hmm.
The DLC has recommended my name, but SLC rejected on the ground that my father had not minimum of 3 years balance.
3 years benefit.
Yes,
But that was set aside.
that was set aside.
Set aside by the single
And
judge,
the matter went to
affirmed by the division bench.
Yes, a division bench. So lost
When was
this-
when was the DLC
DLC
meeting?
recommended.
DLC recommended,
DLC recommended.
SLC rejected.
SLC rejected.
SLC dated,
Dated lordship 2/3/2023.
sorry? 2/3.
2/3/2023. And DLC recommendation was on 7/12/2022. DLC
DLC is
7/12/22.
DLC recommended, SLC rejected.
SLC rejected.
And that office memorandum is dated,
Yes, lordship, the office memorandum is at press lordship.
that compassionate families pension scheme
Lordship, pension scheme that is after Lordship 1/4/2017. My case is before that. So it will not cover the
No,
pension scheme.
okay, I'm asking you the date of that OM.
Date of OM Lordship 1/6/2020, 15, page 19. This OM will be applicable.
Still, you have not answered my query. I am asking you about the OM by which that compassionate family pension scheme has been introduced.
Well, that has not been annexed, Lordship.
You don't have a copy. You know the date.
That
Where she got? That OM which I gave you yesterday, no? Let us just have a look at that. This is 18 September 24.
September,
18 September.
18 September.
And you
If
file
it
your
be-
writ petition when?
My lord, my writ petition is 2012. Because that OM, as per OM Lordship, that OM, if the Lordship government employee dies after 1/4/2017, then that scheme will be applicable.
That also is not clear.
Not in this case, Lordship, because my father died on 24/3/2017.
No, that is also not clear because why I'm saying is that this OM, if you read this OM of 18 September 24, it says
24, that is regarding not to hold DLC and SLC. Prior to that, Lordship, we have filed this writ petition.
that I know.
Yes.
Please understand. Please listen to me also. You are only concerned about your relief straight away like that. It is said that in view of the circumstances mentioned above, has been decided that no cases of appointment on compassionate ground to the family members of state government employees who died in harness or retire prematurely on being declared permanently incapacitated for service or missing and whose whereabout is not known prior to 31/3/2017 shall be entertained. So there's something wrong with this OM.
After that, Lordship, this honorable court.
You're saying it should be after that, correct?
My case is prior to that.
Your case is prior to 31/3/2017.
Yes.
But this OM itself says that
But to that effect, Lordship.
no case for appointment would be entertained.
After that, Lordship, the Lordship kindly peruse this one paragraph of
Who is appearing for the government? Oh,
paragraph 9.
But P Das was supposed to be here, your lordship,
Huh?
for this matter. P Das, your lordship.
doesn't matter. I think you are also aware about this notification, office memorandum.
Kindly peruse paragraph 19 regarding that notification.
What is this thing you're giving me?
That is that our High Court's Lordship decided.
No, I'm not on that. I'm on the office memorandum. You have the office memorandum. You must have heard about the compassionate family pension scheme,
Yes, your lordship. Yes, sir.
correct?
Yes, your lordship.
So the last paragraph of this OM, is there some error? Clerical error or something? The idea is to stop the compassionate appointment and to begin giving compassionate family pension. Instead of appointing, now they'll give pension.
Yes, sir.
Cutoff date is given,
Yes.
31/3/17.
Page number 3, your lordship.
See, all those who have expired before this cutoff date will not be covered.
Your lordship.
Those who claim after this date will not be covered. That should have been the thing. Instead, you write the OMs is the other way around.
Page number 53, it says that your lordship, remaining service period of the deceased government employee is less than 3 years. Only 1 year, 9 months, 7 days were left for retirement, your lordship.
You also have not understood what I want to say. That particular provision has
Yes.
been struck off, has been struck down by a single judge,
Yes, Your Lordship.
affirmed by the division bench. So there's no question of debating that issue now. Finish.
Yes, Your Lordship.
What I'm saying is that there's a cutoff date. Who will get compassionate appointment? Who will get family pension instead?
Yes.
So in case of those persons who expired prior to this date, this is 31/3/2017, they will not be covered by the
Yes.
new family pension scheme.
Yes.
Instead, they will be given the appointment. But those who die after this date, they will be giving the pension only.
Pension.
But the wording given in this OM is just the opposite. This is what I don't understand. I'll just read again. In view of circumstances mentioned above, it has been decided no case for appointment as compulsory ground for those family members. No, I'll just read again. It has been decided that no case of appointment on compassionate ground to the family member of the government servant who died prior to 31/3/2017 shall be entertained, which covers your case,
Yes.
which says that you will not be entertained because you died prior to 2017.
31/3/2007.
17.
Now, it doesn't make any sense. Supposing those persons who died after this date,
Yes, they will
They
come.
will not
they will be given compassionate appointment.
After 2017.
But the aim of this
They will not
OM
be
is to
granted, Your
stop the
Lordship.
compassionate appointment.
They will not be granted a pension, Your Lordship,
My
after
lord, there are two
2017.
guidelines, two office memoranda. One is relating to family pension in lieu of compassionate appointment. And another one is, your lordship, I think, relying on 18/9/2024. That is regarding stopping of placing the matter before DLC and SLC. And the person lordship, another OM is that those person died after lordship 1/4/2017, after 1/4/2017. Their case will cover that their family member will get full salary up to the date of actual retirement. But my case will not cover to that OM.
Point is, what is the cutoff date?
That is a cutoff date is 31/3/2017.
17.
Yes. On or after 1/4/2017.
If your family member dies
dies.
before that date,
Yes.
you will get compassionate appointment.
No, they will get full salary up to the age of retirement. That is the age up to 60 years of the deceased. And so far,
Miss Therapy, you just read, both of you just read, what do you understand by this? The last paragraph. Yes, Mr. Khan, also you read. Last paragraph.
In view of the supplementary, it has been decided that no cases for
Compassionate ground to the family members. Prior to about.
Shall be entertained by any. Result. Not be closed before the results. The case of no time have been taken after taken. Well, something is provisional, but last line is
See,
clear.
what I understand is that if the government servant dies before that 2017,
Yes.
they will not get compassionate appointment. They will not get compassionate appointment. So the reverse is that if you die after 2017, your family member will get compassionate appointment. But the idea is to stop that compassionate appointment. Idea is to stop. Instead, give compassionate family pension. After some time, what will happen? Some understanding will be coming after some time. You also tell me, you all are the government side, this scheme is there.
The first paragraph, I think first paragraph is very much clear of the OM.
It's not clear, that's why I'm asking you. In principle, we know that compassionate appointment is stopped now, isn't it? It's stopped. Instead, what is given?
That is given the
Pension. Pension till the date of his retirement.
Till the
That
date.
pension is given.
Yes.
So now, this OM, what does it say? Those government servant who die before 2017, their family members will not get compassionate appointment.
But in the second line, it says, Your Lordship, died in earnest after 31/3/2017. Oh, that's right. But on the last line, it says that Your Lordship,
Last line is clear.
who died in earnest after 31/3/2017 have been taken care by way of compassionate family pension scheme.
In lieu of compassionate appointment.
Okay, last part seems to be okay.
Yes, Your
But
Lordship.
the beginning part, the idea part seems to be something wrong. Something wrong there.
The reference of the another OM is given, that is 14/9/2017. That is
Look-
related to lordship.
Lordship, that let the government advocate be here, Your Lordship, so that. My lord, in this case, my lord. Come, my lord, he is on lakes, my lord. So matter may be taken after some time.
Coming back to the present case, what do you say?
Lordship,
Present case.
the instructions then, Your Lordship, regarding this.
No. What instructions will obtain? Facts are clear. DLC recommended on 7/12/22. SLC rejected on 2/3/2023. Ground for rejection is that balance of 3 years is
Yes,
not
Your
there.
Lordship.
Balance of 3 years is no longer a debatable issue now. Settled.
Yes.
And that office memorandum is dated. Please give back.
3, Your Lordship, 31/3/2007.
No. Dated it 18/9/2000.
18/9/2024.
18/9/2024.
2020.
Now, the present writ petition file in
August
13 August 2024.
12.
When writ petition was filed, this was not in the picture.
Yes.
So, this way or that way, this will not apply.
This is-
So, since that balance of 3 years is no longer a valid ground for rejection, you have to reconsider, that's all. Can we not dispose it of?
Yes, Your Lordship, yes.
Part Mr. M. Khan, learned counsel for the petitioner, and Miss S. Terangpi,
H, Your Lordship.
H. Terangpi, learned standing counsel, Secondary Education Department. Anybody else? Having regard to the nature of grievance projected by the petitioner, the writ petition is taken up for disposal at this stage.
3 and
Stop. It is the case of the petitioner that his father died in harness on 24/3/2017 while serving as a grade 4 employee in Dhakwa High Madrasa, bracket now high school, in the district of Barpeta, Assam. Stop. The petitioner, being the only eligible son of the deceased, submitted an application for compassionate appointment on 11/10/2017 before the respondent number 5. To stop, the district level committee, Barpeta, What is where is the page number?
Page 27, Lordship, 7/12/22.
No, page number of the annexure.
Page 27, Annexure 6.
Which met on 7/12/2022. And your name?
Page 29.
You recommended? The name of the petitioner for consideration by the state level committee, bracket SLC, for appointment to any grade 3 post under any department oblique office. So, however, when the case of the petitioner was considered by the state SLC, which held its meeting on
Page 33, Lordship.
2/3/2023, page number,
33, Lordship.
no relevant page.
Relevant, Lordship, 53. 53 bottom. In the table, Lordship.
What's his name?
Abdul Alim, Mohammed Abdul Alim.
The this is not rejected, it's deferred.
That is amounts to rejected. Because the ground is given, Lordship, because many
Deferred
cases-
and rejected is not same, Mr. Khan.
Yes, absolutely, Lordship, in actual meaning, it is not same, but they have it is deemed to be rejected because the ground is given.
The claim for compassionate appointment of the petitioner was deferred on the ground that his father, his late father, did not have the balance service of 3 years at the time of his death. Top aggrieved the petitioners before this court. Where is that judgment?
That's what page 57, relevant, Lordship, is 81.
Next para. The issue as regards the requirement of having balance service of 3 years in order to be considered for balance of 3 years in order to consider, you can cancel that. Balance of 3 years for the government servant in order to consider the eligible person in the family for compassionate appointment was dealt with by a single bench, by a coordinate bench of this court in various writ petitions filed by different persons on the same issue. Stop. All the writ petitions were taken up for consideration, and the court, wide common judgment, an order dated 31/2023 with WPC number 1646 of 2021 as the lead case, held that insistent of balance of 3 years of service would be violative of Article 14 of the Constitution, and accordingly, the said provision was struck down. Stop. The said decision was put to challenge before a division bench of this court.
my lord.
Page,
That is by
In-
judgment and order dated 12/12/2025.
you have a copy.
Next one, ideas. Epilogue. Epilogue.
In writ appeal number 287 of 2023. Apart from similar other writ appeals. Stop, all the writ appeals were taken up together for consideration, and the division bench, by common judgment and order dated 12/12/2025, upheld the decision of the learned single judge. Stop, therefore, the issue with regard to the government servant having a balance of 3 years of service at the time of his death is already settled. Stop, therefore, the decision made by the SLC in respect of the petitioner in its meeting held on 2/3/2023 in the considered view of this court cannot be sustained. Stop, accordingly, the same stands interfered with. Stop, it is also observe that although the state government in the Department of Personnel bracket B had come up with office memorandum dated 18/9/2024 providing for the compassionate family pension scheme in lieu of compassionate appointment. But the same cannot be made applicable to the case of the petitioner. On the ground that his father expired in harness on 24/3/2017. Prior to the cutoff date provided in the office memorandum, that is 31/3/2017. And secondly, the instant writ petition has been filed. The instant writ petition was filed. There are two dates. What is this? Round seal. Kim, just come here. What is this? Two seals. Two different dates. Filing. So which one should we rely upon then? Yes, just have a word. I'll take the earlier date. Just find out. Was filed on 12/8/2024. Next para, in view of above, the respondents are directed to place the case of the petitioner before the next SLC for considering this case for compassionate appointment. Anything else you will mention?
Time period may be given because they are presently not holding perhaps SLC. So some time period.
Within 3 months, but my lord, only in accordance with law, as observed by the legal bench in the school.
Time frame.
3 months.
3 months. But because at present there is no government. But system is.
In the next SLC, and at any rate, within the outer limit of 3 months from today, in accordance with law. Okay. Mr. Pegu, you're here. We were just having a discussion regarding the OM. That compassionate appointment has gone now.
Yes.
Now it's the compassionate family pension.
Yes.
And instead of appointment, they'll get the pension till the date of retirement of that government employee, correct? Now, what is that cutoff date given? Whose case will be considered under this new scheme?
In this present case,
Ah.
before that the scheme came up,
Hmm.
within 3 months. So the balance 3 months period of the disease serving.
You just go through the OM dated 18 September 24. 18 September 24.
That period is already over.
There is one date given here, 31/3/2017. 31/3/2017. Cutoff date. To my mind, 31/3/2017 is the cutoff date. Whoever expires after this date, they will come under the new
Compassionate family scheme.
scheme. And those who expired before this date, they can be considered for compassionate appointment. That is the understanding I have. But then the language given here is different. It's just the opposite. So those who expire after this date, they will get the compassionate appointment. Earlier expiry means you will not get. It cannot be. It cannot be. So I don't know. There might be some typing error, whatever. You just see, okay, because this is not the only case. Other cases will come up. I think we'll have to get it. There's one matter which we heard yesterday also. Mr. Chamoy is here. I don't know what to do with that. What can be done?
Perhaps today will be some time constant. If your lordship pleases, will have to fix it a very short date if you're according to your lordship's convenience.
One thing I would like to find out is now the argument was started regarding on the maintainability.
My lord.
You want this court to decide the maintainability by a separate order. Depending on the outcome, we will go to the merit. Is it like that?
It was projected by them like this.
Or we hear the entire
Yes,
matter?
yes, yes.
Hear the
Entire matter. That's
Better.
better, man.
Hear the entire matter, and
Yes.
if I find something there in the maintainability part, we
That can be,
we cut it off there only
Yes.
and finish.
Yes, yes.
But if I find that it's maintainable, then we go to the merits.
Yes,
Like
yes.
that.
Well,
hear the matter.
So otherwise, like we'll have to have two dates.
Thus-
One to hear the
to
maintainability.
exercise unnecessarily.
Not
to
necessary,
exercise. Yes.
unnecessary.
Yes. Yesterday I pointed out, but senior counsel said that we want to address it on first.
Then
So-
lordships hear the maintenance part also, then lordship have to enter the merit also lordship.
Huh,
If he-
That
because-
is better.
if-
That is better. We complete the argument on the merit also.
Because the merits,
Yes,
because
because lordship, there is just some issue is there regarding getting the financial aid or not lordship.
Mm.
That part is the merit part lordship. If he is getting the financial aid, he is automatically come within the purview of the.
they have admitted that they get financial aid.
2001 rules lordship. When lordship, our High Court Division Bench has already held it. lordship.
Yes, so what is the
When
dates?
Supreme Court also held that lordship, a public function is lordship, they have service, then also it come under the 2026. 2026.
That's the Z telefilm judgments.
June. Okay, okay.
Lordship, we kept it as a part heart, my lord, then, my lord, it will reduce our burden, my lord. If Lordship pleases, of course.
First week of June will be beyond 30 days. So there's no scope for keeping it part. It has to be before 30 days.
Any date, your Lordship,
21.
as per your Lordship.
21.
There is a standing order.
I understand, my lord, as per your
If,
Lordship.
if 1 month expires, it gets released automatically.
Huh.
That's
That is
why we cannot have a very distant date.
No, we want the shorter date even,
This is item
30, 49 and
Where's the 21 5.
49 to 51, is it?
Huh.
Oh, give me one date then. Where we can have 20.
prior to that.
Actually, we have also some urgency because of the because of the subject to the outcome, we cannot appoint a regular principal lordship, and there is a pressure from the BCI. It's a law college, your lordship.
Urgency is from everyone. Urgency is for you in your case. But court is here sitting for everybody.
That is why I prayed, my lord, as per your Lordship's convenience, not according to our
Then
convenience.
Lordship 21 5 also.
No, prior to that, if it is possible, then why not?
Him, what, any dates which can be given prior to that?
Can it be on lordship the week earlier, lordship?
14.
14.
What is,
Yes.
what is
Then,
there
I
on
mean,
12th?
can be
12th.
12
Let us have it
weeks.
on 12th. We'll try. It's a part matter. We'll give preference to this. On 12th.
My lord have kept on part.
Yes, yes.
Oblige, my lord, delay.
Due to time constraint, the matter could not be taken up today. Release this as agreed to by the parties. Release this matter on 12th of May.
As part.
This is in the hearing or what is this?
This for admission hearing.
12th of May as part.
I'm deeply obliged.
And the remaining cases, I think we'll have to adjourn it. And court master will look into that dates.
In case of 24 date, I am praying for a fixing of a date. Item 24, I am praying for fixing of a date, madam.
No, definitely. So what I'm saying is that court master will see the diary and accordingly give you a date.
Well, in item 46 and 47, there's an interim protection, man.
That also you mentioned. That also will be taken care of.
Right.
Look into that, okay?